And we're in Book 30A, and we started out with the topic under section, starting at section 17, remedy at law, and we've been on that topic. And we left off last week at section 27, where we're going to pick up, and that's torts generally. Section 27, torts generally, in the 30A book of Corpus Juris Secundum, CJS. So the general rule is that unliquidated damages for a tort cannot be recovered in equity. So in cases of torts to the person, the legal remedy is ordinarily considered adequate. The general rule is that unliquidated damages of a tort cannot be recovered in equity. Ordinarily, an action at law affords a complete and adequate remedy for a common law tort, and actions do not pertain to courts of chancery except as an incident to the giving of equitable relief. And in cases in which the moving party seeks to recover damages arising from the commission of a tort, not associated or connected with an independent equity, courts of equity will not intervene, but will leave him to his remedy at law. And even that a court of equity has no jurisdiction of cases arising out of torts. Where personal property has been taken, withheld, or otherwise dealt with under circumstances, creating a cause of action for its value against the wrongdoers, a such remedy at law is unimpeded. The injured party must pursue it and cannot resort to a bill in equity against the tortfeasors. The rule is otherwise, however, where the legal remedy is adequate and where it is sought to reach the profits gained by the wrongdoers rather than the damages suffered by plaintiff. Ordinarily, one must rely on his remedy at law against an attorney, an agent, or other fiduciary, or a public officer for negligence or misconduct. This rule is inapplicable, however, where a discovery is required in CJS accounting under Section 26. Equity may require the rendering of an account where there has been fraud on the part of the fiduciary. In cases of torts to the person, the legal remedy is ordinarily considered adequate and equity does not interfere. A complete injury to real property stands on the same basis as one to personality, and the remedy must be sought at law where such remedy is unimpeded unless some special equity exists on which to found the jurisdiction. Averments of conspiracy and breach of trust do not, however, confer jurisdiction if the action is really one arising in tort, for which an action at law for damages is an adequate remedy. Mere insolvency or inability to respond to a judgment for damages for a tort is not alone sufficient to support jurisdiction and equity, although there are cases in which it is said that if the particular case defendant is insolvent and on that account unable to make an atonement, the injury will be deemed irreparable and without adequate remedy at law. The wrongdoing or the wrongful or fraudulent destruction of an equitable right is a loss, a damage to the owner of such right, and is subject to legal redress in an action at law for damages. Statutes authorizing attachments in equity are construed as not giving equity jurisdiction in causes of action ex delicto unless such jurisdiction is expressly conferred. Next subsection, continuing trespass. Equity will intervene to prevent a continuing trespass. A continuing trespass, such as will justify equitable inference, must be of such a character that the recurrence is not dependent on any act to be done by any person. Next, section 28, recovery of personal property. In general, equity not ordinarily take jurisdiction for the sole purpose of decreeing a delivery of personality, but may do so in some circumstances, as where the remedy at law is impeded. For the recovery of personal property wrongfully held, the common law actions of detenure or replevin or analogous proceedings at law under the codes generally afford an adequate remedy. According to equity, will not, when such remedies are available, take jurisdiction for the sole purpose of decreeing a delivery of personal property. However, where replevin or detenure would not afford a complete remedy, equity will interfere. and as part of the relief, decree the delivery which might be had through replevin. Where the remedy at law is impeded or inadequate, equity will take jurisdiction, and in some statutes give equity jurisdiction of suits for the redelivery of goods and chattels detained from the owner and secreted so that they cannot be replevied. Equity will decree a delivery of chattels to prevent a multiplicity of suits. Next subsection, as incident to other relief. Equity will decree the delivery of chattels when such relief is incidental to the exercise of an underlying equitable jurisdiction, as where it is required for the purpose of enforcing a trust, or where plaintiff is entitled to an account, or to a specific performance of an agreement. Next section, B, property of peculiar nature or value. Peculiar nature. Equity will enforce the surrender of personality which is of such a peculiar nature or value that its loss cannot be compensated adequately in money. While the equitable principles here involved are usually discussed in connection with the right to specific performance, the jurisdiction of equity is not confined to that remedy. The equity will enforce the surrender of personal property, which is of nature, a peculiar nature or value that is loss cannot be compensated adequately in money. Equity will enforce the surrender of personal property, which is of a peculiar nature, or the value that its loss cannot be compensated adequately in money. So a court of equity may enforce the surrender of chattels which have been obtained tortuously or which are wrongfully held if they consist of heirlooms, paintings, or other works of art which have a sentimental or unique value or no readily market value. The property must, however, have a special value according to a praetendium affectionis. Next subsection C, securities or evidences of property. Where the legal remedy would be inadequate, equity will decree the delivery of the securities or evidences of property to those from whom they are improperly withheld. Equity will decree the delivery up of bonds, notes, shares of stock, and other securities and evidences of property to those for whom they are improperly withheld, where the legal remedy would be inadequate, as, for example, where they have a special value apart from market value, or where defendant is insolvent. Likewise, equity may, for the purpose of perfecting and quieting title on the equitable owner, decree a delivery from the legal owner. Sounds like trust to me. From the trustee, from the legal owner, to the beneficial owner, the equitable title. Continuing on, equity will not, however, exercise jurisdiction where an action at law in replevin or for damages would be adequate, and the mere fact that the value of bonds or other instruments would be difficult to prove does not furnish a reason for resorting to equity. Next, section 29, recovery of real property and trial of title. Equity will not ordinarily take jurisdiction of suits to recover possession of or title to real property, but may do so in some circumstances, as where the legal remedy is inadequate. Equity, as a general rule, will not determine title to real property. A court of equity is not ordinarily the appropriate forum in which to try questions of title. One relying on legal title who seeks only to recover possession of land held adversely or whose rights are sufficiently protected by putting him in possession usually has an adequate remedy at law by ejectment, writ of entry, or whatever possessory action prevails in a particular jurisdiction, and equity will not take jurisdiction for the sole purpose of restoring possession. Where the controversy involves merely the legal title to lands, there is ordinarily an adequate remedy at law, and the case is not one for the jurisdiction of a court of equity. The rule is applied where the issue to be tried is one which could be raised in an ejectment, as where the title depends on whether or not a deed was delivered or on the sufficiency of a description. It is also invoked where the legal title depends on construction of a will, the jurisdiction of equity in such cases not extending to the determination of the legal title created by the will, unencumbered by trusts. Even where one of the parties is already forfeited by judgment in an ejectment, another action in ejectment, rather than in equity, must be resorted to in order to obtain possession and where another action is available. The courts have also refused to entertain bills requiring that trial of titles which might be tried at law where the object was other than the recovery of possession, even where equitable relief is sought. The general rule applies where the party in possession traces title through a void conveyance, even where the invalidity is due to fraud, and also where the conveyance is based on void judicial proceedings. The restitution of possession is the only relief sought, or is all that is essential to plaintiff's protection, at least where the invalidity appears on the face of the proceedings. A bill for possession will not be sustained even on equitable title against one in possession without title, or under an adverse claim and not subject to equity, the remedy in such case being for the equitable owner to clothe himself with a legal title and then proceed at law. The rule is, however, otherwise where a defendant is subject to equity, even though ejection may be maintained on an equitable title, jurisdiction is not conferred, contrary to the general rule, by the insolvency of defendant or the existence of a disputed boundary. Equity will not take jurisdiction as a substitute for an action of ejectment. So an ejectment bill, which under the guise of asserting equitable rights, in fact seeks to accomplish an ejectment, will not be entertained. The rule that equity will not take jurisdiction of suits to recover possession of or try title to real property is not, however, universal, and courts of equity may, under certain conditions, protect and enforce legal rights in real estate. Thus, equity will take jurisdiction where it is uncertain whether the legal remedy is available, where the legal remedy is not in itself adequate, where the aid of the court of equity is necessary to remove obstacles which stand in the way of successful resort to an action at law, or where threatened damage is irreparable. Likewise, equity will enforce legal rights in real estate which are undisputed, or which are so clear that there is no serious dispute as to any of the material facts, and has full and complete jurisdiction to try and determine the question of title where there is no real dispute over the title. In the latter case, or when the legal title is not in doubt, there is no reason to require the parties to resort to a court of law to determine the title issue. Next, Section 30, extraordinary legal remedies. Equity will usually not interfere where relief may be had by extraordinary legal remedy, such as mandamus or quo warranto. Inasmuch as quo warranto are proceedings in nature of quo warranto, or in some jurisdiction, mandamus, afford inadequate and generally exclusive remedy in such cases, a court of equity will usually not interfere to try the title to an office of a corporation, or to try the validity of a corporate organization, or the validity of corporate acts. For a similar reason, equity will not interfere for the purpose of compelling the performance of a duty imposed by law where a mandamus is available for that purpose, unless it is made to appear that the remedy by mandamus is inadequate, or there is present some other equitable ground for interference. Allegations of irreparable injury and hardship do not in any wise change this rule. Section 31, appeal, certiorari, and motion. Equity will not review proceedings of administrative or non-judicial character where an adequate remedy is provided, as by appeal, certiorari, or motion. As shown infra in Section 63, it is not the province of equity to review proceedings at law and grant relief against where errors or irregularities, the remedy therefore being by appellate proceedings. The same principle has been applied where the statute affords an adequate remedy against proceedings of administrative or non-judicial character, either by appeal or by certiorari. The same rule applies where relief can be had by motion in a law court. It is immaterial to the application of the rule that such remedies have been lost and are no longer available, even where a case presents error of law which cannot be reached by certiorari. It furnishes no reason why a court of equity should take cognizance of the matter. equity will interfere where it becomes necessary to prevent a multiplicity of suits or irreparable injury, or where the remedy by appeal has failed to eliminate the law violation or gross abuse of discretion, or where the proceeding sought to be annulled or corrected is valid on its face, and the alleged invalidity consists of matters to be established by extrinsic evidence. Where equity alone can grant adequate relief, exhaustion of a statutory remedy of appeal is not a prerequisite for relief in equity. Where an appeal is not permitted by law, an unsuccessful attempt to prosecute such an appeal was held not to bar relief in equity. Next, section 32, defenses. Defenses available at law. Relief will be denied to one seeking the aid of equity against a pending or threatened proceeding at law, where it appears that the matters relied on are as such as, if established, would constitute a defense in the law action. One having a good defense to an action at law ordinarily may not resort to equity for relief. So relief will be denied to a person who seeks to the aid of the court of equity against pending or threatened proceedings at law, where it appears that the matters relied on are such as, if established, would constitute a defense in the law action, and where plaintiff's right will be fully protected by a successful defense. That is, where no wrong is threatened beyond the assertion of the legal demand, open as it is such defense. Where, however, equitable rights exist which are unavailable in action at law, it is no objection to the suit in equity that the bill also disclose legal defenses to the action at law. Likewise, relief in equity is not precluded where obstacles exist to the assertion of the defense at law, or where remedy by defense at law is not necessarily adequate, as where the judgment is such action at law is not the sole possible source of injury to the plaintiff would be exposed by its prosecution, or where the title to realty is involved. Next subsection, equitable defenses. Although there is also contrary authority, it has been held that where equitable defenses have become available at law, equity nevertheless has jurisdiction to enforce such defenses. I'm going to read that again. Where equitable defenses have become available at law, equity nevertheless has jurisdiction to enforce such defenses. Thus, some courts hold that equitable estoppels may be enforced in equity, although available as a defense at law. Other courts take a contrary view when the case is not otherwise of equitable jurisdiction. And I thought of the example here as being the unclean hands, where unclean hands doctrine would be both statutorily and equitable. Next, section 33, relief sought available at law. Whether jurisdiction and equity should be declined because of the existence of an adequate remedy at law depends on the nature of the relief demanded. Whether or not jurisdiction in equity should be denied or declined because of the existence of an adequate remedy at law depends on the nature of the relief demanded. Although a bill contains averments which might sustain a prayer for equitable relief and support equitable jurisdiction, nevertheless, if plaintiff asks only a decree for relief, which he might obtain on the facts stated at law, he will be regulated to his law action. The same result follows where equity exists and the bill prays not for relief, which might be granted, but for relief equitable in form and not grantable in equity because the legal remedy is adequate to accomplish the purpose relief sought. Next section, 34, classes. Classes of legal inadequacies. 3 classes of legal inadequacies give rise to equity jurisdiction have been recognized. The failure of the law to recognize a substantive right, the inadequacy of relief afforded at law to protect a right, and the inadequacy of procedure at law to establish a right. Let's boil that down. 3 classes at law inadequacies. Number 1, failure of the law to recognize a right. Number 2, inadequacy of the relief to protect a right. And 3, inadequacy of procedure to establish a right. Now notice they all 3 have something to do with a right. Continuing on. While the Chancellor derived his jurisdiction from the inadequacy of the original writ to enforce recognized legal rights, equity in time came, as shown in Section 40, to recognize and enforce substantive rights which the law either denied or refused to recognize. Let me read that again. To recognize and enforce substantive rights which the law either denied or refused to recognize. And in such cases, the remedy at law is not only inadequate, but entirely absent, or at least was so when jurisdiction was established. As discussed in Section 24, the mere existence of a remedy at law is insufficient to deprive equity of jurisdiction unless it is adequate to protect the right asserted. The flexibility of equitable procedure may, as shown in Section 37, be a ground of equity jurisdiction. And this rule is applicable where the rules of procedure in the law court present obstacles to the attainment of adequate relief at law, even though the right to a plaintiff at law is fully recognized. Thus, equity may take jurisdiction where it is sought to set aside an instrument which is void, the invalidity not appearing on its face, or where the legal measure of damages affords inadequate relief. Now, subsection parties. Since the procedure at law requires that plaintiff must have a common interest and that defendants must be charged with a common liability, a resort to equity is necessary whenever complete and adequate relief requires an adjustment of diverse rights among the parties. Thus, the impossibility of the same person being both plaintiff and defendant in an action at law often confers jurisdiction and equity to enforce a demand of such a nature that the same person will be required to be joined both as plaintiff and as defendant in an action at law. Likewise, the rules requiring those having a joint interest to unite in an action at law to enforce the joint demand will confer jurisdiction and equity where the parties will not join or cannot do so without defeating the action, and therefore one or more of them is left without a remedy at law. And I'm going to stop there, and we're going to pick up next on Section C, which is particular grounds of jurisdiction under Section 35 in general considerations. And that's going to start on page 201.
Q&A session started.
All right, you'll have to press *6 and then followed by *1 to get in the queue line to ask a question. So we're going to open it up for questions. Press *6 and *1 to get in line, to raise your hand. Anybody have a question? Press *6, *1 to get in the queue. Nobody's on the board yet. Bill, you're unmuted.
Good evening. How you doing, Christian?
Good. And you?
Good.
Welcome back, Saturday.
Thanks. Well, based on what you're reading tonight, it seems that, well, my question is, do we still want to lean more towards getting release in equity as opposed to at law?
Yeah, that's where trust is operating. That's where it has its sole jurisdiction, and that's where we want to be in equity, right? This is just kind of revealing some of maybe the tricks and the traps that may be used to deter you from getting into equity, or if you are in equity, to pull you back out of equity.
Well, when we're talking about torturous claims, there is no remedy at equity for that. So I guess what I'm asking is, could you expand on or expound on See, in other words, at equity, we're just going to be having something done to protect a right or prevent people from taking a right.
Yes.
As you said before, there is no monetary relief. So how do we go about that if we want to do that?
Don't claim any torts or any privileges granted to you by statutes and codes. Stick solely on rights, which is specific performance according to, say, a trust.
But I thought specific performance was not within the scope of trust.
Oh, yes, it is, because that's where the duty and obligation of the trustee comes in. Otherwise, it would be a breach of trust or a breach of fiduciary duty.
Okay, so if that's true, then what's going to happen then is we're to make assert that our rights have been, it's a breach of rights, and therefore we're entitled to what?
Well, if we have a private trust and we have a trustee who is not doing the duty, that is a right for the beneficiary to make a claim for a breach of trust or a breach of fiduciary duty. So that is an enforceable right in equity because it's a specific performance that's not being done.
Does it carry a monetary punishment?
It can, but not in equity. Equity will force the performance. If you want to claim damages, that's at law.
Okay, then. So basically what we're saying is that the equity is used to compel the trustee to do
right.
or refrain from doing.
Yeah, rights and rights alone, enforceable rights.
Okay.
So if we stick to rights and rights alone and we don't claim any kind of statutory claim, then if we rely just on maxims, that's what equity is enforcing, then if we just stick with rights, specific performance, then we're limiting it to solely equity.
All right, say with the traffic ticket, we're going to compel them by trust to what? To to let us go or respect our right?
Well, what is the right? You have to establish the right first.
The right to travel.
Okay, I'm afraid that's been played many, many, many times before, and it doesn't work too good.
Okay.
Except I think it was claimed at law, and that's where everybody goofed up at, because they never expressed it to be a trust right, and therefore was not enforceable under trust, and it was not being applicably applied under an enforcement for a breach of that trust and an enforcement of the right.
Right. So then, that's what I was saying. That if traveling is a right, and we've been, stopped from exercising our right, then when we're in equity, we're asking them to stop breaching or taking away our right by the trust mechanism.
Yeah, but somehow they've been getting us to stay on the at-law side rather than come into equity and have enforce the right for whatever it might be. Maybe we put too many statutes and codes in there, and that nullified it right there.
Well, yeah, because we don't own the statutes and codes. That's their stuff.
Yeah, let's take the doctrine of unclean hands as an example that I picked out.
Okay.
And I mentioned that. That is solely an equitable right, but what they've done is they've come up with a statutory doctrine equivalent that if you claim it, you can't claim equity. You're going in at law. So that's the thing. Is there a statutory equivalent that you're claiming and not knowing it? Or are you just going on the maxim that should be solely in equity?
Well,
you're being blocked by these statutory enactments of something that's being duplicated in the statutory public realm that's available for you solely in equity. So they're being mirrored, and then you fall victim to the mirror of the public side.
Right, but can't you stipulate which one you mean in your paperwork?
Yes, that's correct. But most people are going to pick out, say, the statute, and they don't know the difference, how to hold it from going into at law. And then if they could get into equity, they lose it in equity for some reason.
What do you mean they lose it in equity?
Well, just like Franklin was asked when the woman came up to him and asked, what have you given us, Franklin? And he says, I gave you a republic if you can keep it.
Mm-hmm. That's
our problem. We aren't able to keep it by a certain kind of knowledge of the special or the extraordinary or the exigent circumstances, the speciality of the private side, which represents solely substantive rights. And we're being tricked on its equivalent by looking at it on its face value to choose the at-law side, which looks just like the equitable one. And then you've got an adequate remedy at law, and you're barred from equity.
It sounds like you wrote that. So if we do get into the court of equity, you're saying that we have to still be aware that it might try to bounce us out.
Yes, right.
Mm. And then on the other hand, we have to make sure that the maxims we use to go into equity are not the mirrored ones that are in the public.
Yeah, because the equity's main maxim is he who enters into equity must be doing equity. That is the unclean hands doctrine, but that's got a statutory equivalent. If you choose that statutory equivalent, you got at law and not equity.
So how would you word that?
I would claim the maxim and the maximum only. Don't claim the statute that's the equivalent of the unclean hands doctrine.
Oh, I see. I thought you meant that if you just said unclean hands, it could be construed either way.
Yes, could be.
So if that's the case, then wouldn't I say, well, I'm choosing the unclean hands doctrine at equity, the original equity, not statutory?
Yeah, I might go as far as not even mention unclean hands doctrine at all. I may just state maxim and implement its meaning.
Well, yeah, it's kind of interesting, but you have to be vigilant at all times to traverse back into that law side.
Yeah, we're going to have to learn a whole lot more than what we've learned in the past.
Yep, that's for sure. Okay, that's all for now. Thank you.
All right, thanks. I appreciate that.
Right.
Next caller. Anybody who wants to get on the queue line, press *6, *1. Dave, you're unmuted.
Well, hello, Christian.
Hey, Dave.
Got
any oil spilled juice up there?
Any what? Oh, gosh. It's terrible. It's horrible. I don't know what they're going to do about it. It's not good. Anyway, my question would probably be more basic. Trying to get in on the tail end of this, it looks impossible. As far as a learning curve, what are we really looking at if we started now? With like a year, 2 years?
Oh, there's no fine wine before it's time. Now, I can't say, whether I could put a time limit on it, but I could say I could probably put a determinative number of hours spent at it, which would probably be 1,250 hours.
Oh. Okay, so this sounds like it was designed to be so complex that, the average person just not going to even have a chance at it.
Well, not really. Have you ever read the book, The Art of Sun Tzu? The Art of War?
Yes.
Know your enemy and you'll be successful, but know yourself, you'll be successful. But know your enemy and yourself and you'll be really successful. I think the hardest part is getting to know them and what there are the tricks and traps. You could just study yourself, and yourself would be just, say, equity. And if you just studied that, you could probably do pretty good just at that.
Now, when you say them, are you talking about the judiciary or the
at-law side, which is public, and the equitable side, which is private.
All right. Well, if you're going up against the average attorney in some kind of litigation, he's not going to know very much. So your real average...
Right. Whatever he knows is probably all public.
Exactly. So are you looking at the real enemy being the judiciary?
Possibly. Well, the judiciary is the attorneys. They're all the same club.
Okay, so the judge is an attorney, but he's supposed to be a nonpartisan.
Supposed to be. There's where I'm going to have to know their rules in order to keep that judge a judge.
So is there any place for coming in their court as in other words, making the court a common law court and operating that way?
Common law is held in trust, and I don't think you could probably claim that, because what are you going to claim under common law? Because there's no common law, there's no money. Well, common law requires money, lawful money.
Okay, well, we got property, and they're trying to steal your property.
Yes, that's where trust comes in, because if there's no common law and there's no money, what filled the void?
Property.
Trust. Everything is being gifted into a trust.
Okay, so let's take like one of your children. They're in their early 20s. They don't really know what's going on, but they say, Dad, why don't you take this trust stuff you're learning and help me out here? I'll make you the trustee, and you go do everything. Do like you're supposed to do.
Well, that's a lack of responsibility, and that's immaturity of children. And even if somebody is 90 years old with that kind of attitude, they have not achieved the age of majority, and they're an infant, and they're a guardian ward of the court.
How many beneficiaries are in that same category?
Many. Almost all, I'd say.
Okay, so isn't the trustee's job to take care of the beneficiary?
Yes, but suppose that nobody needs to know there's a trust that was formed, and then they got you under debtor-creditor.
Look, if I'm in that position, if I'm the beneficiary, and I made somebody like you the trustee, why wouldn't you do your job? You're going to protect my interest.
How am I going to do my job when you guys, the rest of you guys, don't know what your job is?
Sherry.
Yeah, it's like everybody has to kind of like share in the knowledge and know that, hey, we are really down and out from a lack of knowledge.
That's
and
right.
We all need to get that knowledge and start putting our heads together and, united we stand, divided we fall.
Okay, but you still got 1,250 hours of a mountain to climb. In the meantime, you need some relief.
I know, but I would rather say that I would rather lose what I've got and not cause myself any more problems and study like crazy to get the knowledge that I need and then go get my property back.
Now, what kind of problems are you talking about?
Well, my problems would be that they would tack some other stuff on there because I'm trying to do something I really don't know what I'm doing, and I'm trying to enforce something I have no idea what's going on.
So they're trying to punish you to teach you a lesson. So
Yeah, because all I'm doing is making general deposits. I'm not withdrawing them from general deposits and making them special deposits under trust, and that changes the jurisdiction. If I don't want to be a defendant in court, I need to do a withdrawal from general deposit and do a redeposit under special deposit and change the jurisdiction from defendant under at law and bring it into equity under a different jurisdiction. I'm no longer a defendant.
Now, when you're talking about making a deposit, can you be more definitive on exactly what a deposit is? What does it look like?
That's a special deposit, a trust deposit under Black's Law definition, and it was done under a trust.
But what does it look like? Is it a financing statement? Is it some kind of document that you record?
No, I just grant you my pen to be returned to me sometime in the future along with my interest. That was a special deposit.
Okay, but something initiated that, and to make the withdrawal, how are you going to do that?
Well, you see, you thought I lent you my pen. Well, I appointed you trustee of my pen for a specific purpose, and then I wanted it returned sometime in the future along with some kind of interest.
Okay, well, let's take an example. When you get a Social Security card, that's a trust relationship. That's not your card. They entrusted that card to you. They can ask for it back any time.
No, that's under debtor-creditor. But now you need to change the relationship from a debtor-creditor relation to one of trust, and that card is yours. That card has always been yours. You just never knew it.
All right, besides doing the SS5, how are you going to express the trust?
We're going to use the UCC and the county records as manifestations of the trustee or the grantor's intent. Let me say that again. It's UCC's as a non-UCC filing and the county notices that creates the manifested intent of the grantor. And then we're going to use those records to prove the trust. Now remember the maximum that no party in the trust need to know that a trust is being formed or operated, really. Now the only time somebody needs to know that the trust is being formed is when you're going to do some kind of enforcement. Somebody's got to know to enforce it. But that's the trick, how they've been getting you. Everybody doesn't realize that everything that's happening today in every kind of relationship or transaction is really a trust. But they don't need to know that a trust is being formed for you. But you're really being tricked to form the trust yourself. That's the whole lie. But that's the real beauty of the trust. Now, if you understand that, you can use that against them.
So in any action, you would just go into the county and record a UCC-1 without recording it with the Secretary of State?
Well, no, I'm using two record witnesses, UCC-1s and the county. Those are just two notices.
Okay, so one is
two notices to prove any kind of fact. Two witnesses.
Okay, so the notice in the county is like an affidavit form?
Yes, could be, yeah. But I'm not putting any details in the public. I'm just making reference that something exists in the private where the details are. And the notice in the public contains very little information except it's just got enough information to point to the private documents being held in the private.
So am I wrong to assume that you take your notice into the chambers and tell the administrator or the magistrate that, excuse me, but there's a trust here and I'm the guy?
Yeah, basically, yes.
And this is how the cow eats the cabbage. Now do it. Something like that?
Yeah. And then there's the power of equity to enforce. And also the big thing about it, trust, is that the onus of probandi shifts to the one, and that's where the moving party does not have to prove up anything because it's assumed that the other party is guilty.
Right. So the onus is on them, and when they don't prove up, what's the result there?
Yeah, all I got to do is make a prima facie case and proof that there is a trust, and then the court of equity is going to assume that the beneficiary, once he makes a claim, that the trustee is guilty. And the only way the trustee is going to prove himself to be innocent is if he has a record of a payment.
Well, how does the fact that the trustee come to light?
Through the beneficiary making, but his claim won't stand until he's proven there is a trust, and he is a beneficiary.
All right. Now,
if he's challenged, put it that way.
Okay, but let's say the beneficiary is incapacitated or is a minor or is incompetent, if you will, and appoints a trustee to watch out for their interests.
Yeah, possibly.
Okay, so I go in as a trustee.
A separate trust. But you see, there should be a trustee on that trust already, and that trustee is supposed to be doing his duty. So if the beneficiary can't, because he's incompetent, come out against the trustee for a breach of trust, then somebody else is going to have to step in place of the beneficiary who is competent and bring the claim forward.
Okay. Well, let me let somebody else ask some questions. I think I got the right idea.
Okay, well, come on back in if there's nobody in the line.
Thank you, Christian. How do you get off?
You'll get muted out. She'll mute you. Daniel, you're unmuted. You're next.
Hey, good evening, Christian. How you doing?
Hey, good.
Great. I came in the call a little late. What was that you were reading from? Was that Corpus Juris Secundum, Book 35?
Book 30A.
Oh, Book 30A. Okay.
Yeah, we started at Section 27.
Cool. Section 27. Okay.
Torts generally, and then we finished up the section to the next main topic.
Looks like that's where they buried a lot of, a lot of information as far as equity and law, huh? In that particular book.
Yeah, everybody thinks all law is the same kind of form, and it's not. Equity was actually to smooth out the rough places under common law or statutes and codes where the law was too harsh or there needed to be some smoothing out of the rough spots, really.
Well, I guess you can't fit every real life situation into some sort of a statute, like cramming a round peg in a square hole. It just won't work.
Yeah, and
so,
that's where equity came in. Yeah, that's where equity came in.
You were saying how if you invoke a legal remedy, then you've excluded yourself from equity. Now, do you think that would be the same for, let's say, if you're doing an administrative process, using like a UCC, was that 1-210, like a debt val or something like that? Now, would that be considered or construed as a legal way of going about it that would bar you from equity?
Possibly. We're starting to look at that. Yeah.
Yeah.
Now, there are different exceptions that certain things are. This is like these rules are like created that there's exceptions to everything, and it's like however way they want to treat it, they can do it.
Right.
Unless you got the know-how to block them.
Because I'm almost thinking like a debt val should almost be a very private correspondence, and no more, no more citing sections, UCC, 3- whatever, and just simply say you have my property and I want it back, and then that's it. We're not invoking anything. I'm almost thinking these correspondences should be almost like conversational, almost.
Yes,
that casual.
Each claim's solely just a right of enforcement, just like you said. I want my property back.
Right.
Because you took it wrongfully or whatever. Then that would be purely just an equitable claim.
Right.
Just stuck with that and that alone, that's purest form. Now, if you want to try to give them some kind of way out so they can save face, now you're going to bring in some kind of at-law colorable thing. That might jeopardize your equity because you don't know how to keep it from sliding back out of equity because now you've got an adequate remedy at law.
Right. Well, what I'm almost thinking is let them worry about how they're going to save face. Let them devise some sort of a statute or code that a judge puts in at the last minute to make it look like, everything was business as usual. Well, why should that be our
And here's how the rules are written so that they've got that power, that discretion to say, oh, no, this is not equity. Then what do you do?
Then you repeat it 3 times like Dorothy did with her heels. and you just stand your ground and don't leave that court until he gives you what you want. Or they drag you out of there, one or the other.
Yeah, but you better know the grounds you're standing on, or else they're probably going to, get you anyway.
Right. Well, if you didn't commingle the two worlds, and you maintain equity and you maintain trust, and they're still trying to steamroll you, then I guess that's all you can do is just dig in and not quit. Demand equity, and maybe tell the judge that several times. This is a trust matter. This is a special matter. And,
there may be things that we're looking at trying to find that will reinforce that position or that point so that they can't take it from you.
Right.
Because as I was reading in there, I don't know if I can find it real quick. 3 classes of at-law inadequacies were the failure of the law to recognize the right, the recognition of the right, and the inadequacy of the relief to protect the right, so to protect the right, and the inadequacy of procedure to establish a right. So they're failing to recognize the right, they're failing to protect the right, and they're failing to establish the right. That's exactly what's happening today.
Right.
Now, how do you prevent that? That's the key.
Well, you practice and
that's the whole
rehearse.
reason why equity was created. But now they've got such a lock on the equity side that is what is happening today. You are being denied the recognition of the right. You're being denied the protection of the right. You're being denied the establishment of the right. You have no rights. That's the problem.
Well, I guess we become just as good as actors as them. You stand in that court, and you're standing in front of an Oscar-nominated actor. That judge is upholding an image, and he's wearing a costume, and he enters stage left. I mean, it's a show.
Yes, we are the last vestiges of a total collapse of a judicial system, and we better get that in our heads.
Right. So, getting back to what I was thinking before, so all these administrative processes we're doing on mortgages and the banks and whatnot, citing certain UCC codes and citing certain statutes and fair debt collection practices and RESPAs and this and that.
There's a more fundamental problem, and that's the total collapse of the judicial system for those 3 facts.
Right.
We're being trained to go fight at law and think you got a remedy, and there's no adequate remedy at law possible, period. So why go fight there?
Well, it seems to me that once we become familiar with trust and equity, actually coming in from that perspective is much simpler, because statutorily,
you're going to have to hold the trust line, because if you're at law, you're not in trust. If you're in equity, you're in trust.
Right. But, I mean, look at all the crap you got to learn.
Is trust in equity, not at law with no trust.
Yeah, I agree.
That's the whole key. That's why we're talking about trust and we're talking about equity. Equity is trust.
But just observational, just as an observation, when we come in at law, it's a lot harder because, I mean, look at what you have to be on top of, just tons of codes and you got to go to law school for X amount of years just to learn how to juggle this crap around. Equity's conceptually a lot simpler as long as you just know how to operate in it.
Principles, yeah, maxims and principles.
So now if you wanted to write a complaint, your cause of action, if, like you said before, if you even want to list a cause of action, instead you just list an equitable maxim, right?
I would have to claim a right. I would have to claim a right established by a trust.
Okay. So something like, say, a mortgage example. I have a right to to obtain my property once I have basically,
under trust, it's pretty simple. It's just a breach of trust. That's it.
Right, right. And so if they refuse to give you back your property, then you would just say they're trying to take it with unclean hands, and then you'd follow that with the maxim of, you know, he who claims equity must do equity, right? Or he who comes in equity must do equity.
Right. Yeah.
Okay. So theoretically, your complaint could pretty much just be a couple of equitable causes of action followed by some equity maxims, right?
Right.
Oh, wow.
None of the 63 million statutes and codes and all these rules and garbage and everything else.
Right. Well, we don't want to even think about those things. That's their stuff.
I'm just going to make a claim for a breach of trust, which is a right, and the right is the trustee had a duty or performance to do a specific act which he didn't do. That was not done. Here's the certification that it was not done. This guy is guilty, and when's he going to do it? Equity is going to force him to do it.
Right. Well, I mean, if you've rehearsed that and you walk into court and you just tell yourself you will not deviate from those trust principles, then, you know, I could
I don't
see
grant
how...
jurisdiction. I don't
Right.
grant them jurisdiction. I don't grant that. You set the venue. You set the jurisdiction. Now, if you lost it, it's because you lost it.
Right.
You granted it in some way.
And that
They
could be as
tricked you
simple
to
as...
change your intent by some kind of manifestation of some kind of act that you did.
And that could be as simple as stating your name to the court, right? When the judge
going
asks
and sitting down when they tell you to go sit down over there, or go out in the hall and get this settled out, you know, with the attorney. Well, no, I'm sorry, they probably just took jurisdiction. You just lost your equity, and now you're at the at-law side.
Right. Just by responding to a directive or a command.
Yeah.
Right. Well, that's all. It's a state of mind at that point. It's a psychological game.
Yep. But if I understand that I don't have to, then all I have to do is just say no. I don't grant.
Just say no.
This is justice on your brain frying like an egg. This is the at-law side.
Pop, crack. Yeah. No,
all I have to do is say no.
This whole thing is strictly psychological. This is psychological warfare in that court. It's got nothing to do with...
Now, let me make a caveat to what I just said. You just can't walk up to the judge in that courtroom and just say, no, I don't grant that, because they're going to clobber you. Unless you the records that you've established a trust and can prove the trust, that gives you the authority, and then you can say, I don't grant that. But if you have not proved trust, you have no trust. And you have no authorship of a grantor or a beneficiary or a trustee.
Right.
He who claims trust must prove trust. If you don't prove trust, you don't have the authority of any position in a trust, whether it be grantor, trustee, or beneficiary. That explains why they won't accept these payments drawn against any SETI key trust or birth certificate trust or foreign situs trust or whatever, because you never claim trust. Therefore, you do not have the position of trustee to make out a check from a trust or a bill of exchange from a trust, because the trust does not exist. You never claimed it, never proved it.
Right, right. It's all about the records.
Yes. Although the trust may be
about
on a private, you haven't manifested the record in their realm and they can't see it. Therefore, it doesn't exist.
Well, but both realms rely on records, whether you're outlaw or in equity. They all require documents and signatures, so why should equity be any different? You know?
It's really not, but you may have two live witnesses that are competent to testify, hey, yeah, they made this oral agreement.
Right. Right. Interesting stuff. It's been a real trip on the brain, that's for sure. You don't even need drugs. Just open a trust law book. Cool. Thanks, Christian. Very informative. Appreciate it.
All right, thank you. Next caller, you're unmuted. Jacob.
Yeah, hi. What were those three things that you mentioned earlier about the rights?
That's Section 34. It's classes of legal inadequacies.
Oh, classes of illegal?
It's classes of legal inadequacies.
Inadequacies.
So legal is at law. So there are three types of inadequacies at law.
Do you have them handy where you can read them slow?
Yeah, number one is failure of the law to recognize a right.
Failure of the law to recognize a right. Number two,
inadequacy of a relief.
Inadequacy of a what?
Of the relief.
Of the relief.
To protect a right.
To protect a right. And number three,
inadequacy of procedure.
Inadequacy of procedure.
To establish a right.
To establish a right.
So really it's a failure of a right, and it's a failure to protect the right, and a failure to establish the right.
Wait a second. Failure of a right, failure to protect a right, and the third one?
Failure to establish a right.
Failure to establish. Okay, so that's 1, 2, 3. Okay, I had another question. He who claims trust must prove trust.
That's the number one maximum of equity. That's the main one.
In order for the arch enemy, the mill foreclosure beneficiary attorney duo, you know, when he's issuing a substitution of trustee and he's appointing a foreclosure trustee, isn't he declaring the trust?
Yes, but who's challenging him?
Oh, okay. I didn't mean to have my voice tone to like that. What I meant was, now the beneficiary.
What is he claiming though? What trust is he expressing?
Well, the grantor trust, or
there
or
may be many trusts that he may be.
Maybe he has maybe it's a new income beneficiary trust.
Yeah, but what trust is he? What trust is he claiming? You know, there could be many trusts out there that pertain.
Yeah, that's why I'm thinking is as we're expressing the trust, so are they. So how do
where'd they get power? Where'd they get their authority?
They got the power. They got the authority from the signature of the grantor.
Yeah.
But nonetheless, if the guy's asleep at the wheel, which is 99.9% of the time, then he's expressing the trust. So I'm just thinking,
who's he expressing the trust for?
Well, he's trying to invoke, the alleged beneficial interest rights.
Well, yeah, okay, but who's he expressing the rights ultimately for?
Well, he's hogging them.
No, he's not. He's doing it for the grantor. Now, who's the grantor?
Yours truly.
Yeah, grantor is us. We're our worst enemies.
But I guess my point is that when
we're giving somebody the right to foreclose on us. How dumb is that?
Yeah, but when he sells a promissory note to another pulling the servicing trust.
Well, no, let's not get caught off in all this other stuff, because what's it all boiled down to?
Okay.
Who gave
well,
them
no,
the?
okay.
Who granted them the authority and the power?
Yours truly.
Yeah, take it back.
Now, okay.
Choice is yours. You had a choice. What was the choice between?
Sorry?
Choice was ours, or the choice was yours. What were the two choices?
If the choice is mine, what are my two choices?
Yeah.
I don't see two choices. I only see one.
Everybody who granted this mess that they'll be come and foreclose on you had two choices. They could either, number one, make a general deposit or a special deposit.
Okay.
It's the nature and character of the deposit that is getting you. Because a general deposit is construed to be immediately by default debtor-creditor.
But is it not? Yeah, but is it not in addition expressing your standing?
Say again?
Is it not in addition to debtor-creditor, it's also establishing and expressing your standing?
Yes, as debtor-creditor.
Yeah.
By default. But the choice was yours. But you can always go back and correct the choice, the wrong choice that you made.
Okay, so
now reckless under debtor-creditor for all this time, and now you've given them power of attorney to foreclose on you, and what did you expect? But you can go back and reverse all that. Welcome to NTT as New Trust Technology.
Okay, so with the heyday of predatory lending, there is a majority number of refinances that are involved. So you have the original grantor trust with the original party, and then you have a refi. Now, you never went in and withdrew your general deposit when they refied the house and asked for your special deposit back.
Right.
So if you do that, what should we expect if we did that?
Probably nothing until you start doing something about it.
No, if you did something about it, I'm saying.
Well, what is it you're going to do?
You're going to go back and express the trust by claiming the trust property. I don't know in a refi if you have to withdraw your deposit, but it would seem that you would have to withdraw the general deposit. And
you're going to have to change the nature of your general deposit back to special deposit, yeah, in some way. You're going to have to do it withdrawal.
Okay.
That withdrawal and that redeposit as a special deposit is going to be a merger of titles, really. It's going to merge the lesser contract, the debtor-credit contract, and the higher, the security, and it's going to extinguish the debt.
Now, I'm talking about the refi, right?
I don't care what it is. It's a refi, original mortgage, or whatever. You got several trusts, but, you know.
No, but my point is when you do a refi, you have this new trust, and you have a new.
You got a new debtor credit. You got a new debtor creditor. There's no trust.
Excuse me. Okay, that's right. Okay, so you have this new debtor-creditor instrument because you haven't expressed the trust yet.
Correct.
But if you express the trust of the current, I don't know how you refer to it. Is it the current trust, or the original trust, and the refi trust, or the refi trust and the new trust? There's two trusts.
You know, why don't we go back to where the first signature is laid down on a piece of paper that started this whole mess?
Yeah, that's going to be the original credit application. Or the original trust for the original loan.
Yeah.
Let's say that's in 2002, and you come back in 2007 and you refi it, but you didn't express the original trust about the purchase of the property.
Yeah.
So
now you got twice the problems.
Right? Isn't that true?
Yeah, really. Yeah, you got twice the problems.
That's the way I see it. So don't you have to handle? I mean, you have two separate scenarios, but they're actually the same. They're the same. It's the same deed that's in the county that they're foreclosing on, the address, block description on. So
yeah, but which one's foreclosing on? It's not the old one. It's the refi.
Yeah, it's the refi. But they didn't. Yeah, it's the refi. It's the new refi deed that's in there.
The refi took care of and extinguished the old debtor-creditor contract from the first mortgage there. But that's the one that's going to foreclose on you, the refi. So that one's become the main one.
No, I follow you. I agree.
Go back in the first one also.
Yeah,
so you got to make your withdrawal, get yourself out of general deposit, and get it under trust.
Okay, but I want to also withdraw the original deposit and redeposit it. No, I want to also withdraw the general deposit. I mean, once it's a past,
there's two notes, right? There's the original one that you never got back, and then there's the new one that you create up the refi, which is the new one.
Correct.
So you got two notes, but it's the second note that's getting you.
No, but what about the first note? Forget it?
Well, no, you ain't got time unless you do have time. I'd go back and worry about the one that's biting you in the butt right now, which is the second one, the refi. That's the one that's closing.
What about the folks out there?
Under debtor-creditor contract, you need to do something about the debtor-creditor general deposit that puts you in all this mess.
Okay, I follow you on that, but I'm trying to use this example of the first one, even maybe equated to someone that lost their house or they sold their house and they didn't get back their special deposit.
Yeah, well, you can always go back and get them. But the main thing is you never expressed a trust. You never created any evidence that there was a trust, and there's no trust until you do that.
Okay, so so if a person has a foreclosure on their house or they sold their house, the trust still exists?
No, the trust never existed.
Because they didn't declare, they didn't express it. But if they go back and express it, then it comes into existence, I should say.
Yes, you have to bring it into existence. If you don't, it does not exist in their eyes, in the public. We have to do everything. We are doing everything, but we're doing everything the wrong way under debtor-creditor.
I'll give you an example. My mother just died, okay? And the person that was the gal that was handling it was my sister, and she sold a house. And so there was a sales price, and she closed, and I was thinking that, we never got back the special deposit of my mom.
Right.
So in order to be a model in the family, I was going to go back and express the trust on her behalf and ask for the special deposit back because I'm the oldest heir, okay?
Right.
So,
You got to change it from general back to special. You got to get it under trust.
Okay.
You got to create records to prove the trust, and then you got to make a claim in court on a court of equity in order to enforce it.
Can you do it as an heir?
I would say so. Yeah.
Okay.
I could do it to anybody as long as I claimed it.
Someone that's dead?
Dead or alive, doesn't make any difference. I can claim somebody's property and take it right out from under them.
Okay. Thank you, Christian.
All right. Okay, Floyd, you're unmuted.
What time did you come on, Christian?
9 o'clock.
Oh,
Hour and a
man.
half.
I thought you were on at 10 o'clock. Wow. Okay, anyway, I've got a question about what I'm doing. And on my telephone trust that I have created. Now, in my purpose of the indenture, I put it is the purpose of the trust to hold the specific deposit under claim number blah 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 of the beneficiary in confidence until further notice for future return with his interest, or in the alternative until other instructions are given. These instructions may be changed from time to time by the beneficiary. Now, I sent in the instructions with the res, and I think they were kind of confusing. So what I did is I made up new instructions, and I put, this is my instructions for the special deposit for a specific purpose that accompanied the claim number RA blah 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 0000 for May 19th, 2010. I order you to extinguish the debt and release the funds and return any remainder back to Floyd Bradley Howe. You have 10 working days to send this to the address at the bottom of this notice of instructions. Now, this is what I kind of have a question about. Failure to comply will force beneficiary to seek remedy in equity for breach of trust. Should I put that in there or not?
Well, we kind of talked about that before, I think, on some other calls. That's kind of a discretionary thing you're going to have to use. You're going to have to make a decision yourself. There was two types of thinking here. That, number one, if it was me, I could leave that out because I don't like revealing my game plan to people.
I see, okay.
And then the counter to that is that maybe to somebody else, they feel like that is like rattling the sword at them, and it might strike some fear in them, and they might do what you want them to do.
In other words, it's kind of setting the stage for what is next coming if they don't adhere to the trust.
Yeah, it just depends on which way you want to play. It really comes down to that.
I see. Okay.
And,
anyway, then
there can be some advantages and so say some disadvantages. The advantage is, you may force them to do it, but the disadvantage may be that you just revealed your game plan.
Well, if they know you're going to drag them into a breach of trust, I don't think they want to go that way. At least I wouldn't think they would. I mean, after all.
I don't expect these people to lay down and roll over and give me what I want until I really about ready got the knife at their throat and going to jab it through their heart.
Well, in order to do that, if you actually had to go into court to go into equity, then they know that you're going to have to come up with $300, I guess, to start an action, and they're counting on you probably not wanting to do that or some such thing. So then the best thing to do then would be to start the action if they don't adhere, and then when they get that notice that they're going to be in court, then go from there, I guess, huh?
Yeah, I think that the holding their feet to the fire is when you actually drug them into court, and now you're going to clean their clock if they just don't come up with some kind of settlement with you, or else do the performance.
Okay. Well, so really, basically, I guess it's whatever you feel comfortable with doing then at this point.
Yeah, I would say, yeah, whichever way you feel that, it's going to be advantage that you know how to handle.
Yeah, okay, all right. Okay, then I signed it by beneficiary, Floyd Bradley Howe. Well, I'm going to sign it because I'm going to have it notarized, and I'm going to have the notary send it in to them. So
okay, so let's see. That would be a beneficiary. You're signing by beneficiary, but yet you're going to give them instructions from a grantor point of view?
Well, I was thinking that I was taking the part of beneficiary at this point.
Well, if you're giving them instructions, whose office in the trust is giving instructions all the time?
I thought the grantor was the one that created the trust, and then the beneficiary was the one that gave the instructions to the trustee. That was my understanding, anyway.
Well, yeah, that could be, but I would say it might be more clearer if you still claim grantor position there. The only time I'd be probably claiming beneficiary is if I reserved a right as given to me by the grantor for telling the trustee what to do. Otherwise, I'd play it simple and just play the grantor position. If I was enforcing the trust, then I would probably come in as beneficiary.
Okay, let's see. Okay, according to the law. Okay, what I did is I put, let it be known that Floyd Bradley Howe, hereinafter known as grantor beneficiary, this 19th day of May, blah, 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 being of lawful age and so on and so forth, Commonwealth of Virginia, exercises his right to name as trustee. Okay, I guess I didn't put anything. Oh, wait a minute, I did too. I put these instructions may be changed from time to time by the beneficiary. I put that right in the indenture.
Okay, all right. Well, there's just what I said. You reserved a right for your beneficiary then.
Yeah, I did.
Okay, well, then you could go ahead and do that then.
Okay. Okay, now, I do have another question. I think on May 31st, you alluded to paperwork from ancient archives. And I was wondering, I think it has something to do with the declaration, I believe. Do you recall that?
Do you remember exactly what it was?
Well, that's what I wanted to find out because it had something to do. It had something to do with whatever we're supposedly working on towards the Sedeke Trust settlement, and I was wondering if you could recall that, because I'd like to know what it was. And if we had access to it, if you recall that.
The only thing I think it might be would be that document. It was a 4-page document for the Bank of the United States. And where's it at here? See if I can find it here. Okay, it was a 1794 document. Is that what you're referring to?
Yeah, that sounds familiar. Right. Okay. What is that about exactly? I don't recall that.
All right.
I don't know if there's any detail on that or not. I don't recall you doing that. I think you mentioned it or something.
Yeah, it was 4 pages long, and we circulated out a little bit, and I mentioned a couple times on a couple shows there. It was at a meeting of the President and directors of the Bank of the United States on the 30th of May of 1794, where they were talking about the forms of powers of attorney and the letters of attorney that were filed with the cashier of the bank with the powers of substitution. And it gave examples in there. But on page 3, it was talking about at the lower part that it said, quote, the powers may be made general or special according to the will of the grantor.
Oh, I see. Okay. So that was the crux of the document of 1794 then?
Yeah, that was a reinforcement of everything we've been talking about, that everything is either general or special.
Uh-huh.
And that's your power is the will of the grantor, because power under Black's Law definition is really the ability to choose to act or not act. That's power. Power is not force.
So
power is not enforcement. Power is discernment. Discernment is really age of majority, because now you got at the age of majority, you are operating in power to make a choice whether or not you want general or special.
Right.
General or special deposits. And that's by the will of the grantor.
Okay. Okay. Now, when we're setting up to do our Sedekey trust, I don't like to use the word collapse, but what would it be? The fulfillment of that trust, or whatever.
Terminated.
Terminated. Yeah, okay. Termination. Okay. We have to actually, there's 2 things that we have to do, and we have to, in fact, we have to move 2 titles. Correct me if I'm not seeing this correctly, but we have to move title on our birth certificate, and we have to move title on the Social Security side of it, like the SS5. And get the and go to the IRS to change that IMF file. Is that that's correct, isn't it?
Well, I think you're a little off on the Social Security one. The Social Security one was done to create the establishment of authority position that you were the grantor on the trust.
But we were also the beneficiary. Correct?
Yes, right.
Okay. So,
Social Security. Now, you got to do that also on the birth certificate.
Okay, but that's what I'm saying. If we move title on the birth certificate, doesn't that effectively take away the Social Security Administration's hold on us, or whatever you want to call that?
Yeah, we're doing a withdrawal from guardianship ward relationship and terminating that by asking for a final statement of accounting and settlement.
Okay, I see. Okay, so then that would be in our intent and purpose then, and that would be written into our intent and purpose in the kind of like the instructions to them.
Yes.
Okay. Now, if we do that, and we come up with what we're satisfied with, or what we want to do, then where does the Bill of Rights come in? As far as do we have to lay claim to the Bill of Rights, or do we just have to kind of notice them that we have the Bill of Rights?
Well, that Bill of Rights is, out of the Constitution.
Pardon me?
The Bill of Rights in the Constitution, you mean?
Well, the Constitution. So, would we have to notice the events of the Constitution? The Bill of Rights
the Constitution is a sub-trust drawn against the main trust, and if you pull the main trust out, then you've taken over all the other sub-trusts also. The Bill of Rights that I want to talk about is the Declaration of Independence, where God gave us all the unalienable rights. There's no restrictions on any of them.
Okay, so
the Constitution granted rights. It's a privilege of U.S. citizens, and I'm not a U.S. citizen.
Yeah. Okay. So if I just notice them of the Declaration of Independence, then that's really all I have to do then.
Yes. Yes.
So I don't have to put my name on anything. Like I don't have to get a copy of the Constitution and
no, not the Constitution, but we're going to do that on the Declaration of Independence because everything stems from this country. The foundation is the Declaration of Independence.
Well, why? If the Declaration of Independence is ours anyway, why would I have?
Well, it's ours because nobody's claimed it. How many signatures are on that thing? Is your signature on it?
Well, no, my signature's not on it. But
so did you claim it to be a trust and express it to be a trust?
Well, if I refer to it, couldn't I include that in my?
As far as I know, the only acceptors on that Declaration of Independence are the guys who signed it.
Yeah, I understand that, but didn't they sign that? Didn't they sign that for all their progeny, or the?
Does it look like they? On the conditions of the way things are today, do you think that declaration has got anything to do with what's going on today?
Only because the people don't understand it.
Okay, well, why is that? Because they never knew it existed as a trust, never claimed it as a trust, right?
Okay. Okay, so then we send away and we get a certified copy of the Declaration of Independence, and then we put our name on the allonge or whatever we're going to do, and then that is then that becomes part of the res of the trust res.
Yeah, that's going to set up our standing or position of authority. That along with the Bible, which is where the Declaration gets its authority from.
I see. Okay. So then, are we going to send them the first page of Genesis and the last page of Revelation?
No, we're going to hit them with it.
Are we just going to quote it?
There are really two public documents that probably could be expressed as trust, maybe without, they're so publicly known that there's no question about them.
Well, that would be the Bible and what else? Not the Declaration of Independence, then.
Yeah, the Declaration of Independence in the Bible.
Oh, okay. Well, but I thought we had to have an allonge on the Declaration of Independence.
That might help to manifest a record, but I could manifest a record and still claim something because it all boils down to what's my intent.
Well, I'll put that in my indenture, or whatever we want to call it. I mean, or my agreement. Is indenture a good word, by the way, for us to use?
Yeah, an indenture is an instruction, which is really what we're using to tell them what to do.
Okay, so that's a kind of
agreement.
That's a kind of a portal word because you can use indenture in creditor-debtor language too.
Well, no, I use indenture under trust.
Okay. All right, so then it really isn't a portal word.
Contract under debtor-creditor.
Oh, okay, okay. Well, see, that wasn't really clear in my mind, and that was one thing I wanted to get cleared up too.
Contract or agreement?
Pardon me?
Contract or agreement under debtor creditor.
Oh, okay, yeah, okay.
Those are the general deposits.
So then, if we get a so then are you saying or not? Or are you saying that we do or don't have to have an allonge on the Declaration of Independence on a copy?
For those who don't know what they're doing, I say it's better to have an allonge. For those who do know what they're doing, they don't need an allonge.
Okay, all right. Well, that's what I wanted to clear up there, because that's something that I was kind of concerned about whether or not you did have to have, because as you just pointed out, that those are two forms of
claim of
authority.
Right.
That exist that are ours if we claim them.
Yes, that's the key.
Right, exactly. Okay.
If we express them, let's put it that way. If we express them to be a trust.
All right. Okay. Good. Okay. Well, I don't see any problem there. I'm in total agreement with that one. Okay. Is there any place that I could where can I get that Declaration of 1794? Is there any? Can I Google that?
Do you get on Skype?
Yeah, I got Skype.
Do you get on Skype?
Well, if I need to get on Skype, yeah, but I don't just get on Skype just to get on Skype.
I know, because there's some messages waiting there for you from me.
Oh, okay. Well, I'll look them up then.
If you get on Skype and contact me, then we can chat. I got something to talk to you about, and I can Skype page document to you.
All right. Okay. Well, I'll look at I'll pull up my Skype and look at it then, because I'm so used to using email that that's what I usually use. All righty. I'll look up Skype. I'll get on Skype then. What's the date on Skype? Just because if it's too old, I might have to go way back.
Yeah, it probably doesn't work unless I'm on at the same time too, so it might not work. So. Send me your email then.
All right, I'll do that. All right, I'll send you my email account. All right, I'll do that tonight then.
Also, on this page 4 of this document, under the resolve, on the page 4 at the end, there was a very interesting resolve that says that the person claiming a certificate or certificates had been lost or destroyed, say, and they were saying what had to be done in order to give the bank the authority to reissue the certificates. And they told the person the instructions what to do, and they said that they had to, the claimant shall advertise in a newspaper for a span of time the accounts and to account for the loss or destruction, and describe the certificates and its number, and call on all persons to show cause why the new certificates should not be made out to him or her in lieu of the lost or destroyed ones. And then the second paragraph was then there was an indemnity bond included with that, indemnifying the bank for any kind of damages that would be coming up. And actually, this was a declaration. Now, the party who lost the notes or certificates did not have to go to the court and appeal to the court to reconstruct these certificates, like we're supposed to have to do today.
Uh-huh.
They weren't granted that privilege. They don't have to have that privilege unless you choose to do that. And this is how we give away our rights as a general deposit, and we get a bowl of beans back.
Yeah, we sold our inheritance for a bowl of pottage.
Yes, that's right.
Yeah.
So we have this resolve that all they had to do is put it in a newspaper and do basic government and notify the parties, as do a show cause hearing by paper as to why the certificate should not be issued.
And then was there a specific time, did they say, like 3 weeks or something?
I think it was 6 weeks, I think. Yeah, 6 weeks.
Okay. All righty. Okay, I'll send you an email tonight, and then so I just send it to. I've got 3 emails addresses from you.
One of them is probably closed down because I just abandoned the one Hotmail, and so there's 2 left.
So either is fine.
You broke up. What'd you say?
Either one of those would be fine then, right? For me to send you.
Yeah, the Hush account is. I no longer use the Hushmail account.
You don't want to use it?
The Hushmail is dead.
Oh, okay.
The 2 at Hotmail or let's see, the Hotmail account is in existence. The other one from the website's still down.
Okay, I'll use the Hotmail one then.
Use the Hotmail one.
Okay. Okay. Very good.
Yeah,
All right,
send me
I'll
your
send you
number.
Excuse me?
Send me your phone number.
All right, I'll do that. Very good. All right, I'll do that tonight then.
Okay.
All right, thanks, Christian.
All right, Floyd. Appreciate it.
You bet. Thanks.
Next caller, you're unmuted. Bill, you're up, unmuted.
Yeah, I had a question a couple of years ago. It was just about, when we talk about breach, we're usually thinking about trust breach. However, it can be a breach with an agent or the parties. And I'm bringing it up because, once again, we need to be very specific when we talk about a breach. We can't assume that a breach means automatically trust.
Yeah, it doesn't. It could be a breach of contract.
Exactly.
Yeah.
And I say that because that would take us back into the at-law side. So.
Yeah, usually an enforcement of any kind of breach would be equitable.
I'm sorry?
Usually a breach of any kind would be equitable.
So, in other words, we can have a agent fiduciary breach, and that qualifies as equity?
Yeah, because even enforcement of a lien, say, is an equitable relief.
So that adds another level or layer to how to get into equity. Because some of the things that I thought were at law are actually equity.
In equity, yeah.
Interesting point. Okay, I just want to make that comment so that we were aware of that.
Yeah, because it's not just trust. It's for an enforcement of other. Although trust is solely in equity.
Well, fraud is in the equity. That's one of the ones.
Yeah, because you were making of that omission, fraud, and something else. I think it was 3 of them. I forget what it was. Trust. Yeah, trust.
Yeah,
was
that's 3. Right. And so, if that's the case, then omission. Well, if an agent omitted to do a duty, that would be breach of fiduciary relationship.
Yeah, now here's where they get you on the statutory side, because they say if there's a statutory equivalent, then you've got an adequate remedy in law, and therefore you can't get equity. But you see, that could be an estoppel, really, because they're violating those three classes of inadequacies. But through people's, I hate to say it, but stupidity, we have allowed this to take place.
Well, but see, they're being very fair. If you know that the three pillars exist, then you can, as you say, work around. But if you don't know they exist, then they compel you to go into that law.
Yes. Now, I think there's an equitable maxim that says, he who sleeps on his rights has no rights.
Yeah, probably so.
So I think it's the awakening of that there is something different than at law, and that's equity, and to learn what it's all about. Because that's where our substantive rights really are.
Right.
And that should be able to cut right through the statutory equivalence and get you right into equity.
It's like a hot knife going through butter.
Yes, because it's your choice. You can either do the general deposit or you can do the special deposit.
Mm-hmm.
Generally, it's the at-law side, or specially, it's the equity side.
Right.
What kind of deposit are you going to give into the court? Are you going to grant them a general deposit at law, or are you going to grant them a special deposit in equity?
Well, now, let's look at this. We have an agent, and there's a breach of trust, fiduciary duty. You know, we have financial people who abscond with people's money, like the movie stars have a financial agent, and the person misappropriates the monies. Now, is that a fraudulent claim? Would that be one equitable? Because it's, you know, you have fraud, you have omission, and you have trust.
Yeah, but could it be that they don't enforce that because the ultimate fraud is because we're trying to perpetrate the fraud, trying to collect when there really is no money?
Well, that's a good point. Sure.
And really, if you had the age of majority, you would have known that, and then you would no longer be classified as incompetent, because now you're trying to breach the trust yourself and commingle the private side with the public side, or the equity side with the at-law side. Well,
there you go. I'm right out of equity, back into at law, and I lose again.
Yeah.
On the other hand, now that we know a little something, we could now express trust because we were mistaken in the beginning, and we could go back and, make it.
It's no more likened to. I'm going to bring in some religious things in here. I'm going to say that, nothing more than what happened to Adam and Eve when the devil tempted them, and no more what has happened when Jesus Christ was tempted on the mountain to bow down and worship Satan. Because Satan is always trying to get you to give up everything that you've got to get some little benefit that's worthless, when you had all the rights to begin with and didn't need to do that. That's the whole trick.
Well, that's the Asian majority, isn't it?
Yes, that's the ability to choose and knowing which one's the righteous path.
Exactly.
But that gate always looks more appealing than the narrow gate.
Yes, it does.
And there's where that discernment comes in.
Yes, absolutely. That's like, I guess it's maturity or experiential, and if you do the same thing over and over again, then that's not going to help. But maybe one or two times around, you get the point. I'm not going to do that anymore. So, like you just said with Floyd, you give up all your goodies or your pot of gold for a bowl of porridge, So you have to be aware of that. But that's all I want to contribute, to say that we have to be very careful about the term breach. It's just not for trust.
Uh-huh.
So that would be one of those possible colorable or portal things. Could be at both sides.
Yeah, it could be. Yeah. It's like all this stuff is pretty fluid and dynamic, and it's constantly changing. But yet, how did they put it? Equity was both. Let's see. Let me find it here. I think it was on the other week. I went over it. No, missed it. Someplace in there. How did they put it? It says there was this was out of Section 17, right at the beginning of the Remedy Act law. It says that the touchstone for equity was talking about. The line between the law and equity is not only sharp and distinct, but variable and changing. Like it's a very dynamic thing that in some regards it's sharp and distinct, but in other ways it's variable and changing.
It's mercurial.
Say that again? It's a what?
It's mercurial, mercury-like, If you put mercury in your hand, it just slips all around.
Yeah. It's there, but you can't quite put your finger on it, I guess.
Right, so but those who can see, and those who can hear.
Yeah, and under the bank and banking book also. The deposits. Let's see, where's that at? Find where the deposits is. All right, it's on 269 of the Banks and Banking, where a deposit may be the cloak for some other transaction, such as a payment or the giving of security. And in such case, equity, looking through form to substance, that'd be the law side to the equitable side, substance, will treat the transaction according to its real nature. Real nature, that's equity. Because that's really the law of nature, and nature is God. But that's the cloak. These general deposits are cloaking something. The general cloak. Another form, or excuse me, it's hiding another substance, really. And it's got to look through the form. But that's what equity does. It looks through the form to the substance, and it'll treat the transaction according to its real nature. Anyway.
So then the substance, we use the maxims to pierce the outer veil to get to the substance, the form, the procedure.
Mm-hmm. Right. In the legal definition, or the legal fiction definition of Black's Law, where legal fiction was the thing we must put on. It's the mask that must be worn to pass the bleary-eyed watchers.
Got it.
Legal fiction is the mask that progress must wear to pass the faithful but bleary-eyed watchers of our ancient legal treasures. Ancient legal treasures. That's our equitable courts, our unalienable rights, our substantive rights. But it says we got to put on the mask of the fiction to pass these bleary-eyed watchers. But you know, if you're trying to break in a door and there's bleary-eyed watchers around there, you know, they're gonna see you because you're taking too much time to get in the door. You're breaking in the door. You're making too much noise. But if you had the key, all you had to do is walk up to the door, put the key in, turn the thing, walk right in. They probably wouldn't say anything. So if we had the keys, well, I think we've got the keys. And it's a lot simpler than everybody thinks. But we're so easily tricked, that's the problem. Because we're trained under brainwashing, under social conditioning to not to think, but to react. When they say jump, how high? And we'll always have this society that thinks can't fight City Hall. And everything that law states is righteous. These are all fallacies. Despotism, thinking that whatever government says, hey, we shouldn't question it. Well, I don't know who government is. Is it we the people, or is it the servants? And we've lost our identities of who we really are as grantor, not as secured party creditors. Because secured party creditors is debtor-creditor, it's general deposit. It's not trust. And that's why you can't get an adequate remedy at law, which is the general deposit debtor-creditor solution. But like dogs to its vomit, we keep on going thinking we can get a remedy at a no-remedy side.
But, so isn't that also the debtor-creditor? Is that where we have the guardians?
It could be the guardians, maybe the judges themselves, or the attorneys.
So what I mean is, in an overall social sense, if we don't know there's a trust and we're acting in debtor-creditor, we have to have guardians to oversee our conduct, our behavior, because we're ignorant.
Yes, correct. Yeah, we're not at the age of majority. We're infants yet, and we need the guardian-ward relationship. Yeah, we're wards of the court. And we need an attorney. And they keep on telling us that. If we walked in there and we had age of majority, they probably wouldn't tell us we needed an attorney.
Right. So in a way, it's symbolic, like in the Bible, there's a lot of symbolism. It's a similar journey.
Yeah, there's parallels, yeah. Parallel models there. Okay, is that it, Bill?
Oh, yeah, I'm good to go, man. You know, it's been exhilarating as always.
All right, let's go to the next caller then. Come on back in when you got another one.
All right, peace.
California, you're unmuted. 813? 831, excuse me. 831, you're unmuted. You're unmuted. Okay, let's go next one.
Christian.
Yes.
You hear me?
Yeah.
All right,
Okay.
this is Dennis. Yeah, it took me a while to kind of find out where I was at with. I'm on Skype.
Okay.
I'm Dennis, California, and I was told to ask you straight up on the call, not be afraid to ask for help about what's going on with a foreclosure I have. Put myself out there to these people, to everyone that's learning the trust, and I did some studying. I've listened to some of your transcripts and MP3s, and someone gave their take on what I needed to do, but it would be better for me not to be afraid to ask for help on the call and just jump in and ask you. So, my house has been foreclosed on. I did the sale in March, and I've just been served last night. They put a notice to quit, I think it's called. Yeah, notice to quit. And so that's where I'm at. It's like I've been fighting 2 years with everything I know I've learned and known how to do to keep my house up to this point. But they had the substitution of trustee, power of attorney. They came back in and resubstituted a trustee. And I was preoccupied doing other things, so they were able to just go ahead and do it. I didn't block them. So things kind of moved on, and they went through the foreclosure process. And now it's been, since March, I guess it's exactly just right around 90 days. So now they're asking me to...
Did you fire them as trustees?
I did not. I just substituted the trustee and substituted.
Yeah, that made a mistake.
Yeah. Of course, they know what I'm doing, and now the things that I've been learning over the last 4 days is kind of a crash course on trust, and I just kind of been going over some things like what this one gentleman was saying, that what I really need to do is to claim the trust on UCC1, express it via a document, which they're willing to help me with, outlining the parties, the res, intent, and purpose. Then do the transfers on UCC3 and finally prove the trust via NOI, and I don't know what SOI is. NOI is notice of intent, right? And then that should shut them up, at the very least, make them back off for a while. So if I could get any of that to happen, I'd be smiling. So I know
they had a foreclosure sale, though?
Yeah, they had a foreclosure sale, yeah. Another bank. It was on March 3rd.
March 3rd.
Yes.
So it's been past 30 days.
It has. It's been 90, yes.
I'm trying to think if we could some way. Have you done a debt validation with them at all?
In March of, in July 2008, I did a private notary process with one of the gentlemen that's, brought up, getting in contact with you.
Was there a certificate generated by the notary?
No, it was a private notary, actually. It was a friend of mine that acted as a notary. We were going by the bill of exchange of 1884, when no public notary is available, you can use a private notary with 2 witnesses. Anyone in the household.
Yeah, proto notary then. Okay.
Yeah, so that's what we did. Only I didn't know what to do after I was done with it. They didn't respond, of course, but I asked for original promissory note in it and other documentation to prove the debt. And
I would do some kind of debt validation thing under 9-210A4 and do an actual notary presentment on a public notary.
Okay, so that was 9-2984?
9-210A4.
210A4, okay.
Yeah. And that's basically going to ask them for a 14-day statement of accounting that then you're going to state in there that the account is 0. And when they don't come back and answer that, then the notary's going to certify that that's a default.
Okay. Now, being that I'm not really all familiar with a 9-, it's a 2910A4?
Yeah, I don't know what it is in California there, but it's going to be, comported into some number with that basically in it.
So it's a special form, is that what it is?
Oh, it's not a form. It's a UCC code. It's a commercial code.
Okay. So I would look that up.
Yeah, like 9-210A4 is, that's the UCC, but in Florida here it goes to 679.210.
Okay.
So in every every state's got it in there some way under a different kind of form, a number, but it's all got that 9-210 in it in some way.
Okay.
So
and okay. I was going to say I have a UCC book on my computer somewhere for California, so I can look that up.
Yeah, read that, and you're just going to make a debt validation and say that you are stating that the account is zero and you don't owe anything, and they won't answer back probably. So the thing is, the notary to certify that, and once the notary certifies that, that certificate is the public certification that they've got unclean hands doctrine.
Okay. Will it take does it take a normal process the first step would be to submit the debt validation. If they don't respond in 14 days, it would be a notice of fault, notice of default, and a judgment to the public notary?
Yes, basically under 3-501, 503, and 505 of UCC.
501, 502, 503?
Yeah, 501, 3-501, 3-503, and 3-505.
Gotcha. Okay. All right. And, okay. That, just like that. Now, even though that there's another bank now, it's went from Bank of America, they sold it to E-Trade Bank. I would submit this to E-Trade or the original.
Let's see. Who's got the property?
Who has the property? The account goes to E-Trade, but I'm in the property.
Okay, who's got title to the property? Who at the sale? Who bought it?
Oh, it says E-Trade Bank, and I just found that out. It's called E-Trade Bank, and it's I tried to Google it, but I seem to be coming up with E-Trade, the trading firm. But in there, it sounds like there's maybe a division that does mortgages.
Yeah, okay. I would do it on the original lender, and I would do it on E-Trade that bought the property.
Do it on both of them.
Yeah.
Good deal. Okay, and I should probably try to find out. I don't know how the heck I would find out. Bank of America, no problem.
Now, you've been playing in court for 2 years. You should be pretty much savvy with what's going on and how to put motions and stuff in, right?
No, this is all non-judicial.
Okay.
Trust state. But it's all on the admiralty side.
All right. Well, the purpose of this debt validation under 9-210 is just to set up a notary dishonor, which is a certificate. You're looking for the certificate. That's the proof certifying that they have unclean hands. And that would create an equitable estoppel that I would bring a court action in against E-Trade and the original bank lender.
Okay.
I would come in with injunctive action, putting in a preliminary injunction or a temporary restraining order, freezing all actions of disposition of the property. I'd freeze up the public side with this.
Freeze all actions on the public side.
Yeah.
I had a question because I'm not familiar with the calls because it's my first one. Are these recorded where we can get access to them? If I needed to kind of go over, if I had to kind of go over this and the rest of the call that I missed.
Just do a Google for NTT and my name, and what pops up is going to be a forced share site, and just click on that, and that's got all the audio tapes on there.
Okay, and how soon would this one be available?
As soon as you did a search.
Really? I mean, automatically ends the call, goes up on there. Goes up on the site?
No, you have to take out the site in the search and then click on it, and it goes to the site.
Okay. I mean, but once I get to the site, when is this recording available? The one we're doing right now, if I had to refer back to it.
Right now? Probably not until I get my website back up.
Okay. It's down? Oh, that's something else, too. I went to your site, and it is down, huh?
Yeah, it's down.
Can't get it, yeah. I got to tell you, this is really, of everything I've been studying over the last couple of years, I've been listening to Jack Smith and, Brandon and all those guys and, Winston Shroud and everybody. I just like, ooh, the way this is being explained to me is you've really done a heck of a job putting all this together. And it feels right. It really feels like this is what we need to do. I mean, I'm hearing it. So thank you for all your hard work.
Okay, appreciate it.
Yeah. Thank you for helping me.
Off the process from, what they're going to do with the house, and this debt validation will give you something colorable on the public side to do that with.
Okay. So I may have to step into court, which I haven't. I'm not, I'm not familiar with it. It scares the hell out of me, actually.
Well, then, see if you can find somebody who's up on court procedures that you can team up with and
practice. Maybe practice.
So once you get that stopped, that's frozen, and they won't do anything with the house, then you could come in with the trust stuff.
Cool. Okay, I see where you're going. Okay. Well, thank you. I really appreciate everything. Thank you very much.
And the best way to come at the trust stuff is to go onto that website and download the audios from 11/7 of 2009 and everything forward.
Okay. Okay.
That's all NTT from there on. New Trust Technology.
Okay. So yeah, wherever I see that, download that. 11/7 2000. Okay, I will do it. I'm telling you. Yeah. I've like 4 parts of a trust. I mean, just all kinds of stuff that I just was not aware of. Expressing it, and construed trust. I mean, just a whole. I mean, just little tiny things that just puts the pieces of the puzzle together.
Yes, the debtor-creditor stuff has got a lot of holes and gaps in it, but trust is what brings it all together and connects it all, because it wasn't debtor-credit all along. It was trust, but nobody really knew it was trust, and they're not treating it as a trust. They're treating it as debtor-creditor, but although a trust exists on a private side, but it doesn't exist on a public side until you express it.
Yeah, that was so profound and kind of like, well, it's just so simple. They've done such a great job of hiding it.
Are you aware of the other calls on Monday, Tuesday, and Wednesday?
I have been given the schedule, yes.
Okay. All right.
And I'm going to be on them. Believe me. I want to know how all this works so that I can function in commerce properly.
Well, when you get down to it, you'll learn how not to function in commerce because you don't have to.
Okay. Thank you. It's exciting. It's really exciting. I'm just really jazzed about it. Can't tell you. It's I guess I want to take in more information than I'm ready for. I just want to learn all right now and be there. But it's just going to be a learning curve. So at least I started it.
Yeah, it takes time. It just doesn't come overnight.
But being around the same like-minded people, just learning and listening and okay, well that goes there and this piece sits over here and you tweak that screw over there, and it's almost like I do auto repair, and that's why I kind of liken it to that, like a fine-tuned engine.
Yeah, there's a lot of moving parts here, but they all start coming together.
Yeah, I love it. I really like it a lot. And I like listening to everyone. I mean, all the calls that I listen to, all the MP3s I've listened to so far, and the transcripts I've read, just like is really soothing. Like everything's going to be okay. Don't worry about it. It just sounds like everything is going to be good. Just learn what you need to learn and exercise or express the trust, and then everything will fall into place. That's kind of the feeling I'm getting, which I haven't really ever.
126 2010 tape, that gives you kind of a culmination of everything like in one big package.
Which date?
1/26/2010.
Okay. Cool. I like there's something missing that you don't get from most calls is the real high energy. I like the really low key, everyone understanding what's being said, and there's clarity.
Well, I hope everybody's understanding what's being said. Sometimes I don't think so, but anyway.
Yeah, but I mean, you're explaining it in a clear way, in a concise way. I know it takes a little while to wrap, everyone to wrap their head around it, but I think you do a great job of, kind of gauging where everyone is, and you kind of go to their level to explain to them. That's an art to me.
Well, I try, but I might not be the best at it sometimes, but
Oh.
I try to explain it differently from different angles, the same thing, so
Yeah.
people grasp it.
Yeah. So I'm hoping I can, joining you on another call and let you know what's happened with doing what you've suggested and then move on from there. I'm jazzed about it.
And right now, because you're like in graduate class work stuff here, what we're talking about, and you've missed a lot of basic stuff, so it's really going back in the prior shows and learning what the basic stuff is to get up to speed so we can move on.
Yes, I understand that. I'm kind of jumping in the middle. You're right. So I know I need to do that. But right now it's like, one of the things that was really important to me is, my goal was not to lose my house. And I've been working and learning as much as I can. And sometimes I'm in information overload. And a lot of the stuff I'm finding out has been useless information. Especially after learning, listening to your MP3s and stuff. There's a whole lot that I didn't even need, so.
Yeah, if you could have fired them as trustee by pulling the power of attorney that you granted to them, if you would have nullified that, then they couldn't have appointed another trustee to do the sale.
Well, I thought that was really interesting because they did file a revocation of power of attorney, and if I get the document out here because I haven't looked at it, but I'll look at it again. I'm almost positive I appointed.
Did you notify that?
I did. Let's see, did I have them? Oh, yeah. See, I don't think I did. I just went into the county recorder and it got recorded, but I think. I have to look, Christian. I know it's a very important thing. And it's things like that are kind of like you have to make sure you do, plus not sending them original stuff, keeping the originals and sending them copies. I did that a couple times. I've done things like that.
Yeah, without notice, they're free to go ahead and do whatever they're going to do. But if you gave them notice, then that could bring in another issue because you could use equity to reverse that then. Because they can't take free and clear once they've been notified.
Okay, I'm going to see. I could check that. And once you go on to the next person, I'll get up to my filing cabinet and pull it out. I know I still have it. It's my copy of the recording at the county house, at the county recorders. Mm-hmm. So I'll check it out. I may have had to just send them to me rather than send it to them.
Yeah,
if I did that, I know I didn't do it. But if I did. I'll hit the number 2 again.
Okay. All right.
All right. Thank you.
All right. Okay. Area code 313. You're unmuted.
Hello. Can you hear me?
Yes. Who's this?
Hi. This is Catrice in LA.
Hi.
I had a question. I know you said earlier that technically you could take somebody else's property right from under them if you wanted to with trust. Is it possible to do that if the other person's property is already in their own trust?
Possibly, yes. Yeah.
Okay. If you're not a part of their trust, like if you're not a beneficiary of their trust, I'll just give you the scenario. There's an evil slumlord who owns a property. She's not taking care of it. She's got the worst record in the county, and the tenants have formed an association and have legal representation, and they've been taking her to court, and they're about to do like a damages case and everything else. And I'm just wondering if there's a way to like have someone express the trust as like the grantor and then maybe name the association as a beneficiary, or maybe have the association be the grantor. I'm not sure what would be the best way.
Okay, now, why would you want to take this lady's property from her?
She's not taking care of it. She's got too many violations. She treats the tenants horribly. She's not making repairs. She's gone to jail over this.
Well, how about maybe doing this? Why don't you form a committee that you get a bunch of volunteers and go fix what's wrong with her property and help her out?
Well, we could, but if we're tenants of the property and this person's the owner of the property, every time there's something wrong with it, it's her responsibility to fix it. She's not fixing it.
Okay. Well, I'm kind of saying, have you done everything legally to get her to provide adequate living standards and things?
Well, that's kind of what we're in the middle of right now. So, I mean, I wouldn't do anything until all the legal remedies have been exhausted.
Yeah, I mean, if she's just totally using the trust to protect the property and she says everybody else can, go fly a kite, then, yeah, maybe she's not.
Yeah, that's basically what she's doing, yeah.
Well, see, I don't know exactly what's going on. I'm just kind of speculating, so. I would say, why don't we try the other route, too, and maybe try to help her out. Maybe get some of the people in the community to, I don't know, does the place need raked up and cleaned up, painted, boards need replaced and things?
No, it's much worse than that. It's like health and safety violations, and she just doesn't want to pay. She's very wealthy.
Why is the reason she doesn't want to pay? Maybe she doesn't have any money. Maybe she's in the same position as everybody else is in.
She's very wealthy. She takes vacations every year to Europe. She's got property all over California, and she treats all of her properties this way, especially in LA.
Okay,
She's got the worst record in the county.
Well, if that's the situation, then yeah, you got a right to maybe as a leasehold leasee. That are there leases and things?
Yeah. So now, would the lease be considered the trust res? Like, say, one of the tenants expressed the trust and claimed the lease as the res? Or maybe we should say the association. Perhaps the association would be.
So she has a trust that all the properties are in?
I think so. I'm not positive on it, but I do remember seeing on one of the documents a few years ago that the property was in a trust. But then she's been named directly in the charges concerning the building. So I'm not positive on that yet. I have to find that out.
Yes. You'll have to find out, she may be being attacked personally, but maybe she's not even the owner of the properties.
Okay. So technically she might just be like a trustee or something, or?
Yeah, she could be trustee on her own, yeah.
Okay. So then if she's not the actual owner, if it's actually she's just the trustee, then we wouldn't be able to eventually try to take the property for ourselves.
I don't recommend taking somebody's property, To use the trust that way would be, you know.
Well, I'm one of those people. I don't believe in using stuff the wrong way, but if someone's consistently abusing and misusing, you know, unfortunately, we can't get the property as like co-ops or condos, even if we have more than enough reason and law on our side. We would have to go through too many hoops for like rezoning.
Well, why don't you just move?
I would, but I can't. Most of us can't. We're kind of stuck here.
Well, you know, it's,
although we're still gonna. I mean, you know, we've got legal representation and everything, and we've got the housing authority is working with us because they want to nail this woman too, because she's been doing this a lot. So we're going to exhaust all that first, but you know, I'm just kind of looking at every option available.
Yeah, yeah. Well, I'd go that route first.
Okay. Okie doke. Well, thanks a lot. I really appreciate the calls. I really do. I'm really learning a lot.
Okay. All right. Thanks.
All right. Thanks. Bye.
All right. Next caller. 253. You're unmuted.
Hello, Christian.
Yeah.
Hi, this is Jeff in Washington State.
Hi, Jeff.
How are you doing tonight?
All right. How's things up there?
Wonderful. Our first day of sunshine for months. I've been reading Corpus, Book 39, Guardian and Ward. Section 6 on accounting and settlement.
Okay.
And I'm reading from the 2008 edition. And under Section 207, it says, on termination of the trust, it is the duty of the guardian to exhibit a final account. But it follows by Section 208, where it says relief from duty to account. And the first part says that the guardian is not required to account where nothing taken from the ward. Now, I'm thinking that since everything we have is in trust, that they haven't taken anything from us. So they might not have a duty to account.
All right, so just terminate the relationship.
It also goes on to say, upon majority, ward may waive accounting and join guardian in latter's discharge. That means you can support the guardian in his discharge.
Uh-huh.
So I'm just thinking, in the paperwork that we're going to be forming, we may not need to do an accounting. We just close the account.
Yeah, the accounting might be with the person who's a trust, and maybe that might be the IRS or somebody.
Would you agree that they haven't taken anything from us?
Well, it could be like agent to principal, principal to agent.
Okay, I see that.
They've got all these agencies as leaves on the tree, smokescreen, hiding the fact that there's one trunk, and that one principal has taken the, well, maybe I wouldn't want to classify it as being, they have taken, we have granted it unknowingly into a trust, yeah. But all this stuff seems to tie in somehow together, you know. And I think all the agencies can be terminated one way or another. And if we express the trust, claim that trust, and then we can terminate that trust. If we don't have the right agency or to point towards the principal, we may have to shuffle a few things around, but I think we're in the right direction. Let's put it that way.
How would the ward who now describes himself as the beneficiary, how would he demand an accounting if the guardian says that nothing has been taken?
Okay, then let him swear that nothing has been taken from that, and that he knows nothing about it as being the agent.
And that would be Geithner.
Possibly.
I'm wondering if there's one way to check into it. The Attorney General is also in the office of alien property custodian. And the alien property custodian, I think, would have the records of the guardianship.
Good, I would think, yeah.
There's also another office that I have sent paperwork through. It's called the Office of Foreign Assets Control.
Yeah.
It's in the Treasury.
Right.
And their chief counsel, I've actually had communications from him before. They're the ones that actually work with the Attorney General to manage the foreign assets, which is really our assets.
Mm-hmm.
Wondering if he should be included in a list of mailees.
Possibly. Again, yeah, possibly. Like I
Okay,
said,
I was curious about.
We may have to play around till we have the right parties.
Yeah, I was just curious about this when I read it because it said that, you know, we may stumble into a situation where we're not getting any accounting, and maybe thinking that they have no duty to because everything is still in trust.
Yeah. So I would have them, you know, certify an answer one way or the other.
That would, yeah, I think I would put that in. Okay, thanks. I wanted to clear that up. Appreciate it. Bye.
Okay. Next caller. Carlos, you're unmuted.
Hello?
Hi, Carlos.
Yes, good evening. How are you?
Oh, not bad. How about yourself?
Good. Thank you, sir. Thank you. Real good. Can I add something to your answer to the gentleman that had his home sold at a trustee sale? I think you did a great job in answering about the 9 to 10, which I already did myself on someone that asked me for help. I have a new person that I'm trying to help. It's my wife's niece. She has the same typical problem, identical. And what I did and what I would do besides what she just told him, I would file a bankruptcy 7, BK7, due to the fact, because that'll stop everything. We know that. But bankruptcy 7 is just all documents. I know this is a debtor creditor, but he's got no other choice at this minute. Our main concern is trying to stop them from throwing him out of the home, because
right.
we know that once he leaves that home, they're gonna accuse him of abandonment. We don't want that. He must stay in that home. Obviously, we know that. So what I would do, and what I'm trying to do to this lady, I filed a BK7, and what makes it, in my opinion, and I did the research already, in my opinion, it's better than anything else in all bankruptcies and litigation through the regular courts. This BK7, it's all documents. It's all proven. So what I did on this lady, my wife's niece, I placed everything under the Schedule F. I placed everything under the Schedule F, and that way, I'm claiming that they are unsecured. Everything, even her cars. And when they come in, we go to that in July 7th. We're gonna go to the 341 meeting.
Right.
they're going to ask them to bring in the proof that they are the creditors. Case closed for that moment. Now they're not gonna show up. We know that because they cannot prove that they are the creditors. And then now we have a case that we can take on at the same bankruptcy court, because once they don't show up in 341, I mean, we have the default on our side. So it's a huge win in bankruptcy 7, and I guess that's the only way that are gonna keep him in his house and keep on doing the 9-10A4, because he's gonna need that in the future anyway. So what do you think?
Yeah, that sounds like a good idea, really.
Yes, I think this is, trust me.
90 days.
Yes, this is going to buy him a lot of time. And what I noticed also in one of my brothers, I did the same thing. And guess what? Unlike the Chapter 13, they don't come back and try to lift the automatic stay. This is what's going on in what I'm doing right now. I mean, there could be some different cases, but I'm just telling you what's going on in my area. I'm in California. That's why I wanted to call, and hopefully that's going to help him a little bit. And also, one of the things that he must bring up when he stays in his home, when they don't show up to the 341, he's going to have a judgment on his side. He does a BK7, he's going to spend $300, and that's it. If he goes through regular court, he's going to be spending $300, more money and more money. It's an endless story. And besides, we have a lot of wins. We had a new win in California. In LA County, judge, he gave the win to one of our guys on there. So it's a win-win situation in a bankruptcy court. And before I forget, I wrote this down. He must come back. I hope he's hearing this. He must come back, and when he's trying to sue them for the unlawful foreclosure, in California, they are not recording. They are not doing a public recording of trustee sale, and it's a must in California. That's a big one. And the other big one, it's they assign the trustee. They assign the trustee after the notice of default. I mean, how could they give a notice of default when they didn't have a trustee? Doesn't make any sense, right?
Yeah.
That's a big one. And trust me, I didn't make it up. I mean, Living Life, I went to a seminar. I paid $2,500 to go to a seminar, and I learned a lot of good stuff. This is what I thought it would help him. And also, the notice of default wasn't signed under penalty of perjury. So he's got 3 big ones that he can overturn this thing. And in Bankruptcy 7, he'll keep his home. I'm almost sure about it. I hope that helps him. All right, Christian. That's about it. I just wanted to try to help this guy.
Sounds good. I appreciate that. Yeah.
Thank you. Keep it up. Thanks.
Thanks, Carlos.
Thank you.
Next caller. Stu, you're unmuted.
Wow, you even know my name. Am I coming through?
Yeah, you're on.
Oh, that's great. This works so fantastic. At least you gave me the information. I just wanted to share that there was a call about 6 or 8 months ago. I'm pretty sure it was last year. And somebody was researching the EIN number for the IRS, and they finally got it, and it was the same EIN as E-Trade.
E-Trade and IRS are the same, one and the same?
That's what they were, yeah. That's what they were on about. Now, I don't remember who said what, but it sounded completely reasonable at the time. I mean, these were not, how do you say, crazy people, any crazier than we are. So maybe he can look that up. Maybe it's been referred to somewhere in a post on one of the news groups or something. But thanks a lot for your call. And if he wants my email, I'll look into see if I've got some record of that. It's muchu@yahoo.com. It's MOOCHOO at yahoo.com. So I didn't get the man's name, but my name is Stu or yeah.
Carlos. His name's Carlos.
Oh, it wasn't Carlos that was from California. The other fellow that was on 3 or 4 callers ago there. But anyway, that was a Carlos too?
No, he was, I forget his name.
Yeah. Yeah, but I'm sure he's still on listening. So, thanks very much.
Okay, thank you. Next caller. 260, you're unmuted.
760, you mean? Christian,
you're unmuted.
I wanted, I wanted to ask, you're constantly being put on the spot, and have a lot of background, experience, and you've got Yahweh always working in your premonitions of your forethoughts. And I wanted to talk about discernment, because I think we all have to exercise discernment. In America, for some reason, the word judgment has been getting used back and forth in spiritual/religious terminology and in business life and personal life. And, there's this thing that people think where you shouldn't judge others. And,
It doesn't say that in the scriptures.
Right. In fact, it says exactly the opposite.
Right.
It says that you must, judge whatever it is before you, so that you
it says judge wisely, though.
Yeah, judge wisely. Good point. Okay. Well, in order to judge wisely, you have to have discernment. Would you agree?
Yes.
Okay.
That's the top.
Right. So the issue is discernment. And so there was a gal on tonight that wanted to take her landlord to the cleaners. So she was judging her, and accordingly she came to the,
yes, and I threw out some things to make her see things maybe on a wider path and instead of a narrow path that she sees them on.
Right.
Maybe to take into consideration what this lady is going through, or maybe what she's been through, and maybe not to judge her so harshly just on what you see, but step into her shoes once.
Yeah.
Rather than come out and clobber her with a baseball bat.
Oh, I know. You did such a good job. I was so proud of being on the call with you. You did such a good job. I was thinking, when you were explaining that equity, with all that we've been learning about how to get into a court of equity and about equity, and if you were to sum up equity, could we say that equity is justice and fairness?
Yes, equity is fairness, right.
Not justice?
Justice, right. That's correct.
Okay. Is there any other words that you could give us as far as trust words that we can use? Instead of saying equity, we can say justice and fairness. And is there any other words that you can think of?
Law of nature, nature's God, really. That's equity.
Okay. Okay, with regards to discernment, I was going to give you an example to see how I did. I had about 4 different encounters this last week with trust encounters, and one of them was a man that I had entered into a relationship with that was going to another party and was making my request known in a negotiable transaction, and it was a substantial situation, very substantial, and so the degree of trust had to be at the highest level, because we were dealing with people that had a lot to lose if what we were doing was made known in the public. It was a private negotiation thing. And so he had violated my trust, and he had taken intellectual property of mine, which was my associate, and then he had transgressed that trust and contacted that entity without authority. And then that party was upset because they're a private entity and wanted to remain a private entity. And the other parties that he contacted had a lot to lose because they had, this was a huge type of asset scenario, and if it would have been made known that this particular asset, they were privately offering it, then it would devalue, that asset. So anyway, the gentleman, I gave him an opportunity to cure his dishonoring me by the intellectual property theft. And then I made that known to those parties accordingly, okay? And, it was like the story you said tonight about, the guys trying to break in the door, and, he's trying, a crowbar, and then he's trying a jackhammer, and if he just had the key and he quietly went in, then the neighbors wouldn't even notice.
Right.
And so, but when it comes to discernment, to discern in expressing the trust, if you could give us some pointers on when we need to use enforcement to keep something wrong from happening. In this case, I had called up these people and told them that I didn't want a problem, and this guy that had represented them, he had dishonored them, and I said I didn't want that to occur, so I decided to contact them myself, and I wrote them a short memo, and I expressed the trust in this memo, and I guess discernment would come in at what point do we release, more revelation of the trust, and when do we keep it under our breath? You understand what I mean? In the area of discernment, how are we going to discern when we express the trust outwardly? I can give an example. In this case, I put a short memo to these guys after I had discussions with the minority and the majority stockholders, okay? And I said, it is hereby granted to entrust you with intellectual property, the offer, knowledge of the parties, dealings to date, price, cap rate for such and such, in which special intellectual property was placed in the man discussed who construed himself to be a part of your group as discussed and confirmed. And in that original party stands in dishonor and given an order to cure dishonor in that said party is incompetent in not only his understanding, more importantly in the things of private banking trust. Said party has breached the trust, commingled the special deposit of intellectual property, which carries criminal consequences. In order to maintain honor and not deal with incompetent party, grantor hereby grants and conveys the offered dealings to date, knowledge of parties, price, cap rate, to act as a legal tender offer to engage in special private confidential dealings as discussed. So the question was, did I reveal too much, or did I use my discernment properly to use enforcement before something got out of hand?
I don't know. It comes back down to first the establishment of some rights, and then you could express the trust being that right. But it comes back down to, was that right that you formed into a trust, what was it based on? Was it based on some kind of righteous truth, or was it done for some kind of revenge? That's the issue.
Okay. Righteous truth, or the motive then?
Yeah.
That's the intent, you mean?
Yeah, are we doing it to correct a wrong, or are we doing it just to, be unforgiving and to exact a pound of flesh for a pound of flesh. Are we operating under grace? Now, if you look at the Bible, especially the New Testament, and you see some of the examples of how Jesus handled certain situations, and one of them would be the adulterous wife, or the adulterous woman, I mean.
Absolutely.
You know, there the law stand to condemn her to death.
Stone her to death.
As well as the man that was involved also, although where was he at? So was the law just in doing that? Because that's what the law required. But then he would operate through equity and said, well, let he who has the first sin, you know, cast the first stone. Let him who is without sin cast the first stone. So there's the harshness of the law, but yet the temperance of the law is exacted by the equality of the grace and equity.
Hey, can I give you a hard one to do?
So that would be the discernment.
Okay.
It's on a circumstance by circumstance or case by case basis. But it comes back down to what is your standard, or what is your plumb line, or what is your measure of truth that is your standard. Because it has to be an outside source. Because man today is incapable of anything but total depravity and cannot judge wisely.
You know the story where the two women come with the child and they try to claim the child. They're before the king. And he says, well, let's just split the child in half and each of you girls can have half of the child.
Uh-huh.
You know the story, right?
Yeah. Yeah, Solomon.
Right? And so one girl, you know, relinquishes her rights. Correct?
Right.
And in the relinquishing of her rights, she was awarded that which she relinquished.
Uh-huh.
So I don't know. Maybe I think that's a really good thing that we could work on is discernment. It seems to be really important because.
Well, the measure of truth is it's outside yourself. Due to the fact it's supposed to be written on your heart, but trouble is, due to the hardness of the heart, you can't recognize it because of the total depravity of man. So that's why we have to go to an outside source, and that outside source is really the standard, which should be the Bible.
Well, we know 3 times in a row the most critical problem that we all face in our lives daily, and that is the situation when there's a difference and 2 parties remain unreconciled.
Right.
And how would reconciling differences, you know, parallel discernment and equity?
If that could be achieved, yes, without anybody's infringement further on any rights that they would have. Like a man beating his wife because, you know, she committed adultery, say. You know, okay, so the wrong does not make a right.
Right. or there's the response that many miss when they come to Yeshua and they say that I would like a divorcement from my wife or my husband because of this and that. And his response is that, don't you know that from the beginning that two become one, and that what has been brought together, evidenced by the offspring, cannot be separated. But because of the hardness of your heart in the community amongst who you walk, I would let you have a writ of divorcement.
Right.
So most people would bypass the initial right under that law of nature, and they would comport to the community as opposed to the original precept. So, it's like, Christian, one time you told me, you have to pick your battles.
Right, yep.
And so I'm trying to, organize that standard, that plumb line of how we are to pick our battles in trust. And I guess we would need to sharpen ourselves one against another in the area of discernment, judgment, and the reconciliation of rights.
I would think so. That would help, yeah.
Okay, well, thanks a lot, Christian.
All right, thanks, Jacob.
Mm-hmm.
California, you're unmuted, 831.
Hi, Christian. It's Dennis again.
Hi, Dennis.
Hi.
Yes.
I heard Carlos talking. Is there a way I could hook up with him? I mean, do you agree that maybe that's the best way to go first and then do the 9-2910A4?
Yeah, do them simultaneously.
Okay, right on, okay. So now I just don't know how I would hook up with Carlos. I don't know if there's a way we can do that. I can give him my Skype if that's okay to do over the line.
Yeah, that's fine. Yeah, if you want to.
If he's willing to Skype me at DYork11, he could do a search on me and get me that way. Are you there?
Yes, go ahead. Give it again.
DYork11.
Is that D as in dog?
Yes, YORK11.
Okay.
Okay, thanks. And then I found, and I know I have the originals here in the house somewhere. I just drove me crazy one time, but it is. When it was recorded, it was mailed to Countrywide Bank. Both of them, the revocation of power of attorney and the substitution trustee.
Okay. Did you send them certified? Have a green card that you sent them?
I thought that the recording office, when they recorded it, they would send a copy to them. Because it says when it's recorded, mail it to them.
All right. Can you get some kind of confirmation that they were mailed?
I will check into it. I never thought it would. I just thought that it happened automatically.
Yeah, well, don't assume anything. Go get the actual record in your hand. That way you've got the record that proves that they were notified. And then with that notification, go back and probably get this all reversed.
Cool. So that'd be the first thing I'm doing on Monday then. Thanks. And I know I got the actual originals here in the house somewhere. So I know I have the originals. But they would have some kind of a record somewhere that they mailed it out.
Yes.
Yeah. I just figured they did it. Okay. That's always good to know. So
a certified copy of that. So you got a certified copy. You can prove it then.
Get a certified copy while I'm down there?
Yeah, give a certified copy of the record that says that they sent it.
Okay, right. Thanks. Phew, this would be really great if that was the case, because I have it right in front of me. Good stuff. This is really great stuff. Saturday night I was supposed to go dancing, and here I am.
Also, Carlos was talking about the bankruptcy in 7 there, that the things that he mentioned about the trustee, that it was not properly recorded. You might want to check on that.
Right.
They had no authority to sell the property.
Right. Yeah, that kind of caught my ear. That's why there were a couple things that he said, especially the price for the BK7. Because most attorneys that I went to see long ago wanted like $2,000 to do it. So these are affordable. I mean, dealing with this so far, I mean, I'm just I've just about exhausted all of anything that I had that had value, that far ends. But keep trucking on. I'm gonna not gonna let go until as long as I'm breathing, I'm gonna still do this. I'm gonna do everything I can, learn what I can.
Okay, that's why we're on these calls.
Great. Yeah. Thank you so much. Thanks.
Okay, anything else?
I'm good. That gives me something to do. I'm good. If I have things to do, I could stay on track. It's good. Thank you very much, Christian.
All right. Next caller. Patrice, you're up.
Hello? Can you hear me?
Uh-huh. Go ahead.
Oh, hi. This is Patrice again from LA. Just wanted to jump back on real quick and say I really appreciate the discussion you guys had about what I was talking about, the discernment. I had already decided that I was going to pursue the legal route and everything, along with the tenant association and everything. But I just wanted to say I didn't ask that question lightly. It's not a vengeful thing. I'm a Christian. I've been praying for the woman because I think she needs the Lord. I mean, we've been praying for her. But yeah, there's also a scripture that says, because they have no changes, therefore they fear not God. And I'm not the kind of person that, judges or anything, but I won't go into the whole litany of things she's done, but they have been heinous, criminal, repeated violations. Sorry?
You are supposed to judge, but you are supposed to judge righteously.
Exactly. That's my point. And so I was just looking at ways to keep her from doing harm. I mean, it really is it wasn't about revenge, and it's still not about revenge. It's about stopping someone from harming people who are innocent, myself included. But yeah, it really is. And it's not a battle that I even picked. The association was formed from former managers who had a problem with the owner and helped us form the association. But anyway, I just wanted to jump back in and say I appreciate talking about the discernment, because it really is about judging the right way and filtering everything through the Word,
Yes.
being led by the Holy Spirit and not
I don't
by
know
our own motivation.
I don't know all the facts, so I can't really judge myself. So
it would take too long. It would take all night to explain hidden video cameras and violating our rights. And I've had like 15 different managers in the 5 years I've been here, because
If you'd like to ask a question, please press 1 to add yourself to the queue. Your request has been received.
Anytime she's been to jail in different counties, I mean, I could go on and on and on. So, yeah, I wasn't trying to, and she's been doing this a long time, long before I got here. And if I'd have known, I would not have moved in, probably.
Well,
but,
you don't have to justify it in my book. So.
Sorry?
I say you don't have to justify it in my book.
No. I just wanted to make sure that I was representing myself the right way. I mean, I'm a representative of the kingdom of God, not of myself. So just wanted to clarify that.
Okay, thank you.
All right, thanks. Bye.
Okay, we have an open queue. If anybody wants to ask a question, press star 6 and star 1. Press star 6, star 1 for a question.
Unmuted.
Terry, you're unmuted.
Hey, Christian, how you doing tonight?
All right, how about you?
I'm doing great, enjoying the call as usual. Listen, I have a question that ties in with what the gentleman was talking about in his foreclosure, in which you just responded about the mortgage company should have filed some records. Going back to the definition in Black's Law of trust receipt, it says that it's a pre-UCC security device now governed by Article 9 of the Code, that being the UCC, consisting of a receipt stating that the wholesale buyer has possession of the goods for the benefit of the financier. Today, there must usually be a security agreement coupled with a filed financing statement. Now, that would be a UCC 1, correct?
Right.
And in order to obtain title or beneficial title, which they claim in the mortgage documents, would they not have to file a UCC-1 financing statement?
They should have.
So this security agreement being, I guess you would say, is the deed of trust. Would that be correct?
Mm-hmm.
And the financing statement would be a UCC-1 filing showing there's a lien, because as you know, according to a lot of the codes in the states, it says a mortgage or deed of trust creates a lien on the real estate. Now, if Black's Law says there must be a financing statement, does that mean that the deed of trust or mortgage is actually that financing statement?
Yeah.
So if they file a deed of trust, that's all they need to do, not file a UCC-1?
Well, I think before it's attached to the property, it's supposed to be filed. If they didn't file it, then they don't have a valid lien.
Talking about the deed or the UCC-1?
The deed attaches to the property, the security agreement.
So it's not really necessary for them to file a UCC-1 financing statement?
Well, that would be, today it's just a notice that should be looking in and checking things out, but that's kind of like the jump-off point. That can go either way. That could be the priority establishment of the debtor-creditor relationship, lien, or it could be a trust receipt, depending on what your intent was. And that's really what you have to do, is reverse that intent to be under the debtor-creditor general deposit and reverse it back into the trust deposit, which is a special deposit under trust. Do the withdrawal and the redeposit.
That would have the effect of creating a trust receipt, or?
Yeah, then that UCC filing would be your trust receipt, record of a payment.
So that would be us filing the UCC-1 to get a trust receipt. Therefore, we could go at them saying, basically, they have no beneficial title.
Right, yeah. We need to start creating the records for trust.
Yeah. So like you've been saying, that transfers the title, that beneficial title, to us.
Going to start substantiating with evidence the facts, material facts, that this is now a trust instead of a debtor-creditor relationship.
And when you present that to the judge, he's going to recognize that they do not have beneficial title in order for them to terminate or settle the account.
Yeah, and then we must have the withdrawals.
Right.
We've given them power of attorney to create all these documents for us, all these debtor-creditor documents, then we don't withdraw them. And then we're not creating any evidence for trust, which we should be doing. So everything comes into court, then there are no trust documents to support your position, and they've got all these documents to support their position as you're the debtor. We got to withdraw all the documents out of the at-law side, debtor-creditor side, and start creating documents under the equity and bring them into equity that we've got the trust, the redeposit, under a special deposit.
Right. And then the judge orders them to return the trust rev.
Or use that for an extinguishment of the debt.
Yeah. Which would result in us getting title to the property.
Right. Mm-hmm.
Okay, I just wanted to clear that up.
Purge the titles, yeah.
All right, thanks, Christian.
Okay. That was the last one in the queue. Anybody got one question? We're going to close it up shop then.
You may now ask your question. Muted.
Nobody? Anybody? Going once? Going twice? Santa Cruz, California.
Oh, Christian, it's Dennis again.
Hey, Dennis, go ahead.
Before everyone got off, I just wondered if Carlos was still on. That's all. Okay. Do you know any way of getting hold of him, Christian?
I'll Skype him, see if he wants to contact you.
That would be great. I would appreciate that. Thank you very much.
Okay.
Thank you for everything. Thanks.
All right. Appreciate it.
Yeah, I appreciate it. Have a great night.
Okay, Jacob, you're up.
I know you're cutting the call off, and I just wanted to thank you. I didn't get a chance to the other night when you shared the depth of your heart and, you know, how you understood things and the past, present, and future, and the sanctification being that second dimension. I just wanted to thank you so very much for sharing that with us all.
Well, that's out of the scriptures, really.
Yep. Okay, good night.
Salvation, yep. Maybe we can talk about that sometime.
Okay, bye-bye.
All right, thanks, Jacob. Everybody. Unknown, you're on.
Hi, Christian.
Hey, Shane, how are you?
Very good, very good. Just listening in, and good questions tonight. One quick question. If you're doing the UCC 1 and the 3 and the 3 as part of the process of creating your records, and then I remember there was some idea that when we might want to consider these as something that we want to show in chambers as part of our private record. Is that right?
Right. And don't forget the counties that go along with that also.
Right. Well, yeah, you guys have the county. I got to find out some kind of equivalency for that. But my question is, just as it's more of a logistical kind of thing or application based, is how these documents themselves, they are publicly registered, like the UCC 1s and the 3s are publicly registered documents, are they not?
Yeah, they're just notices pointing to the fact that, hey, there's something going on here and you need to do your due diligence or else you'll be in willful blindness that checking it out.
Okay, right. So, yeah, okay. So what we're doing then is we're speaking referentially all the time then.
Yeah, they're just notices. They're not for the establishment of anything other than we're just giving notice to the public that they need to be doing their own due diligence and checking out further that such and such may exist.
That's including the UCC1 and the 3, like when doing a transfer. So in actual, we could speak, for example, we can just say we're affecting something of a withdrawal of a general deposit. We can actually just speak in that language then. We don't necessarily have to be that specific. I mean, we can say relating to such and such an account per se, but this is in effect something akin to a withdrawal of a general deposit. We can actually just say it like that almost. Can we?
Yeah, but I would hide it by an RA number and comport that to my, connect it to my case number or whatever, account number, and that way I'd keep it hidden, and that would be a manifestation to keep it private.
Got you. Okay. That makes perfect sense. Right. Okay. Right. Create a document and create a number system on it or something, and then we can create our own number systems, and then just make a reference to that a document, a private document is created regarding such and such. Just regarding certain accounts.
Yeah. Ever since 2000, UCC's been nothing but a notice filing. It's not the establishment of any kind of priority.
Well, I guess, to clarify that, that's where Winston was talking about.
It's not establishment of a priority for a lien. It's maybe a establishment of priority for action, but not for the actual formation of a lien.
Yeah, I think the way Winston differentiated it, he said there's the national UCC one, and then there's a state UCC1. And, of course, the state form of the UCC1 financing statement, for example, that's apparently it's there, but apparently it's quite hidden.
Yeah.
You got to call it out or something. Because I know some people have still recently, well, I'm not sure actually when they did it. But anyways, yeah, okay, so I got the gist of my my question. That's kind of what I was thinking about. Thank you.
So any bingos from last night?
Oh, yeah, just letting that one simmer. It's simmering. And I got to go back and look at all those definitions. I'm making a nice Word doc of Lisa's references because actually it's great because, I mean, it's all the stuff you're talking about, and she's laying it out with the references and the books and the numbers, and that's a lot of definitions there. That's a lot of study material right there. So there's lots to do. It's laid out, though, for us. That's the beautiful part of it. It does look like it's laid out. And I think that guy's right. There is a sense amongst us in this group that I'm not sure I'm like 100% confident because I'm a real, bird in the field, bird in my hand man. But I get the sense, the confidence, the high probability, and it's just a matter of due diligence and study. And at least for a change, it's the first time I feel like I'm on the right track, and it's more a matter of time and effort than hope and guessing.
Yeah, right.
So I'll leave you with that. And if somebody else has got a call on, then thank you, by the way, and have a good night.
Okay, thanks, Shane. Floyd, you're up.
Yeah, I just want to let you know that I sent you an email and got the info. So just want to let you know that.
All right.
Okie dokie.
Okay, that's it, folks. Everybody have a great night, and we'll catch you on Monday. Have a great weekend. Night all.